It's not really clear. Yes, not a content matter, not to mention, but the incident matter, or the additional 7 years old, in Straggle of his life. Yeah, I think the vacancy is 1970s. I mean, pardon my lord, item number 51. As you mentioned, the age of the person, my lord, I think I think pardon my lord, item number 51. I think everybody is there, my lord. It can be contained or document. No. I think someone yes, so routine is item 14, 47 and 48, complaints. 13, 47, 48. Hi, pardon. Yes, content में तो मैंने next sitting. Yes, content में तो मैंने not after the person. Not now.
My lord, I beg your lordship's pardon, my lord.
Yes.
My lord, I have a request, my lord. I seek adjournment in item number 64 because today my uncle's first death anniversary.
All right.
Next sitting, my lord, may be taken up.
All right. That will be adjourned. This is case content. The direction of the certificate. Which certificate? Because the certificate is not similar, but the certificate of the district similar. All right. Not now. So you can come back to her pending. The audience of the tender will only the 1.5 minutes terminal. Which department is this? University. Some lawyer appears. Some lawyer is there standing also. And you don't know that. Then you, even if you take up your matter, so you just see if you given this, why should you give this? Even if you're compliant. I'm sorry, the department of contribution. You know the consequence of one country. Again, we also wanted to wanted to. Well, also, the first internet 37,616 maybe talking about by tomorrow because the all such matters will be done after holidays. After holidays, we will plan something. So let's say that the construction has already containers. Despite the school, then what can be done? They can be filed. They can be punished in 2027. And that is not urgent to you. Now, urgent matter that I have already some construction. That I understand. Yes. No, don't be afraid. Yes. Special item matter, item number 1. Item number 1, the Secretary of Orissa State Health and Human Members. I prefer that updated manners. I did I'm always concerned that total public time was to discuss the amount of all that. But where is the second? Supplementary. From CNTC 85 plus. Yes. Which item? Item 1. Yes. Yes. WP content from what? You can not know so connected. Where is the last problem? Last problem was mentioned. Last problem 20. September. Okay. Yes, so what is your standing? Yes, so we can get to sanction that amount. And we believe that we pay 10 days time, yes, the sanction order action was includes, we pay us 10 days time so that we can discuss that amount, or else without this, the when secretary was just a thousand, the secretary, the development, Odisha State Housing Board, Odisha State Housing Board is personally present. Mr. Mahapatra and Council, appearing on behalf of the contributors, has stated that the development authority, that the authority has decided to pay to the petitioner the amount which he was entitled to. Would that be a particular step in 11 lakhs 16,999 consequent upon enhancement of the age of superannuation from 58 years to 60 years. First off, he has brought on record an office order issued on 3/10/2024 under the signature of the secretary. A sum of rupees 11,16,999 to be paid to the petitioner. First off, he has submitted that the said amount shall be deposited in the petitioner's account when? Within 10 days. First off, 2 weeks. First case. Subject. The secretary shall be required. For personal attendance of the secretary stands dispensed with, subject to payment of the said amount in the account of the petitioner. So if it is paid, then you are not required. No, not paid, but I also comply. I come to comply. Comply. Item number 3. In the last address of 20 September, so we will comply with them all. Now they have given an instruction, they have how to comply. And they have told for direction of the display of the representation. I will consider the representation all the inputs and the representation I will consider by what compared with the lawsuit. It is not for. Why are you standing? क्यों खड़े हैं? सर मेरे since the case is pending in the court, he said that they are not giving me consent. कहाँ पे pending? That filed the case bearing number 603 of 2023. What's the question? How which how सर ये जो केस है ना वो उनको दे दीजिए वकील साहब को ये लाइसेंस दिया है Yes. गवर्नमेंट निरंजन लड़का उनको बुलाइए वकील साहब को बुलाइए सब कर लेंगे ठीक है वो बुलाइए उनको कि आप बुला रहे हैं जैसा ठीक है चलिए बात बोलो Yes. Well, the wife of the deceased employee who claimed to the deed of her husband. Maybe, what is the order? Order that about that time, 2/7/2000, what was the order? Order to take a decision on the claim. Was the decision has been taken or not? Admit that actually given will access in the order that the 6/9/2024 has specifically asked in paragraph 5 to affidavit that they have fully complied with dues or not. That's what it is. And it is adjustment time to I have given the instruction. What is it? The amount that we said. I don't know. That's not all. It was stated by learned AGA that the area of salary to the team of it is 1,63,341. Yes, 1,63,341 and 49,000. As compared to him against incremental area salary. So, further sum of rupees 49,000. 49,000? 49,000 has been paid against what? That is further pay under where experience 2017 that the area salary after pay fixes up and against areas of salary. Stop. In such view of the matter, for my opinion, the court's order stands complied with. Contempt proceeding is dropped. Yes. Item of 5. But item 5, where order it is 6/9/2024. Now, the unreported directed the full complaint circulate, whether the order has been complied or not. Until date or not filed the complaint circulate. So, the video. The rate of each pending, 506/2020. The judgment will set up challenge for the SMP. Set up dismiss it. Set up 26 This is the order. In the so-called, they have stated that he is saying that order has been last order it was directed to file complaint. File this matter next week. As requested on behalf of the NGA use this matter on 2 weeks after original. Item number 6 complaint. Here I will go. Item number 8. Other dated 9/2024 and the same. Complaints are included at time. So I was directed to State Council, file the complaint. So I area B to take some time and give that document. Like, on behalf of business matter on Friday announced item 9 Friday 51 26th October. I was going to item 9. Representation has not been disposed of. Not disposed of. And the last time, previous day, we lost the directed to take instruction. Yes, Mr. I'll take instruction by last. 2 p.m. 11 to 2 p.m. Right. So, item number 10. Now, will also bring the also director special state council to obtain instruction and file the complaints. We will provide the contact person. Contact person is acting a lot for relating to renewal of my husband is order. Order was to entertain my application for lease application. We are in application since 1975. And the renewal application to what is the order? Order is to entertain my application and take a final decision, lawful decision within 2 weeks. Yes, sir. Well, this matter will also after last month, but the medical all the matters has one supplementary to help contact. But let's take a look at lots after lot next week. First, whenever we review to file to sequence and file so-called reply. Yes. Item 11, approval. Legal juice. New order dated 19th December 2023 has not been complied. Eviction notice has been issued. And that order is. Where is the order? Where is the order? Order of the 19th December 2024, 7 million. Yes. The resolution dispatched the direction to the authority body to consider the grievance of the petitioner and other villagers as per Annex 1 series, which has already been proceeded, and to take necessary actions thereon. With regard to the alleged encroachment and if necessary to remove the same, but before that, there will be an opportunity of hearing to the alleged encroachers. There is nothing. Well, they have even only noticed to remove by the 15th November 2024. Not even only, and who has endorsed. Another major person. Very good. And whether there has been any opportunity to appear. Well, what? They are not the then why they have not appeared? Well, notice, we have to dispose of at the admission stage and should be done. It should be the state. Yes, madam. This order has been communicated before hearing, before passing of the order. No, madam. Yes. You have disposed of the matter, you have to take the filing, sir. Petitioner has alleged disobedience of an order of this court dated 19/12/2023, passed in WPC number 39491 of 2023. Stop. The petitioner had alleged in the writ petition that some of the villagers had encroached upon a public land. Stop. Upon public land. The petition was disposed of on the very same day when it was taken up with a direction to the opposite party number 1 to consider the petitioner's grievance without a petitioner grievance and take necessary action. Stop. Is stated by the AGA that this has been notified for addiction. Next, I do not find any case, I don't find that in case of deliberate disobedience of this court's order in Merout, also for the reason Merout as a notice for the eviction has been issued, which demonstrates that the opposite parties do not have any intention to violate this court's order. First off, secondly, among the persons who had allegedly encroached upon the public land were not noticed before the said order dated 19/12/2023 was passed. The petition was disposed of on the very same day, and it was taken up in such matter, common sense eviction notice has been issued. I am not inclined to proceed. Within contempt matter, the contempt proceeding stands stopped. Yes. In the order that the 21 actually, the order is to complete the disciplinary proceeding against the petitioner within a period of 4 months. Yes. As you know, no instruction. Actually, last division also stated stands for instruction. Who has to give instruction? Not collector. Collector is not giving instruction. Respectively, two letters are not giving instruction. The petitioner has alleged in the present contempt application disobedience of an order of this court dated 21/8/2023. 31/10/2023, whereby the Collector Ganjam, Collector Kendrapada was asked to consider and examine. How to put it in our time. The very difficulty, Mr. Counsel, is that same day the order is passed. Examining the petitioner's representation. That was the direction. Considering examining it for 2 series. Actually come to page 13 of the order. Yes. 13. Page 13, para 6. The last para 6. The petitioners are stated to be villagers. I am seeing some item 496. Just a minute. I might be seeing some other brief. Yes. That was a comfortable part that to complete the departmental procedure. And I am seeing them. (21/8/2023) passed in WTC number 26548 of 2000, whereby the collector so and so was directed to make endeavor to conclude a departmental proceeding which was pending against him within a period of 4 months. Stop. Next, when AGA representing the contenders, representing the state, has submitted that despite communications made to the collector on suppose which is he has not responded. Stop. Let the collector Kendrapada be personally present in court on next day with his explanation as to why contempt proceeding be not initiated against him and he be not punished for deliberate disobedience of this court's order. Yes. Almost. Item 13. Dismissed. What is that, Mr.? Happening. In respect of that, now they have taken steps for eviction level. Eviction. The petitioner has on that Mr. Jonas, out of station coming next week. Next week, but we see the out of station also. I requested on behalf of the petitioner this matter next week at around 14. 14. Yes, not complying and considering your case. Huh? Consider we are more scared of you than you know. And this matter will actually tell this matter next week. As requested on behalf of the state, the tribunal is this matter on. Yes, item 15. Yes, sir. Running test 10, that is it is 1 to 24. It is proceed direction to the collector therefore to make a case informed regarding my allegation. Regarding your allegation, where is the order? What is the running test 10? Giving that paragraph 8. In the result, the gift person shall instruct the direction to the person number 6. To safely examine the claim of the personer without being influenced by anecdote V/4. Prospective withdraw and utilize to deny except renewed. Except for the Mr. will see the situation is that you file a writ petition today. And tomorrow your writ petition is disposed of. And after giving notice, no notice, nothing. Nothing. No, it was not nothing. No, they filed the counter. What counter? Counter side before year. And they filed the counter after hearing twice. Just a filed the just another counter was filed in this case. The first counter was finished. I'm incorrect. My last chance selection this. Yeah, taking last time they have taken also tools and something with the person who was comply with the that too. Let's look at questions. No. I was so follow my inspector for the it is an admitted when counsel appearing on behalf of the petitioner has submitted that this court's order dated 1/2/2023-24 has not been complied with so far. So, despite opportunity given to the opposing parties, no, neither any compliance affidavit has been filed, nor AGA has any instructions as regards compliance of the order. First of all, list this matter on 10 day and the who is required to comply with. Collector judge can be required to be present personally in court with an explanation as to why he should not be a contempt proceeding be not initiated against him and he be not punished for intentional disobedience of this court's order. Yes, Item 16. Item 16 complies. I'm giving that. Comply with it. 17 complies. 17. Yes, comply with. Item 18. Item number 18. known here from there for the petitioner is right. Repeated calls. Any instruction? No. When counsel and AG does not have any instructions as to whether this court's order has been complied with or not. So later so-called reply be filed on behalf of filed by the who is the company? Collectors to explain as to why contempt proceeding is not initiated against it. And he be not punished for intentional disobedience of this court's order. Yes. Item 19. During the compliance of the order dated 15 to 2024, the annexure 1, but there is a clear direction in para 8 to conduct the inquiry by 15 March 2024. Specific direction is there. Para 8, page 13. Yes, one opportunity. One opportunity. Investigative, all the districts, all the persons are present. And one of them is very good. Maybe all of them. We don't know. From the last episode that we have seen narrated, the state council to take instruction whether the cases have been disposed of by the opposite party or not. All those focus may have been discussed. Whether it has been complied with or not. But direction of question is one of the my election. One of the disposal of complete assessment, all that I've seen. I'm not in that. But I have other different segments. I'm not going to directly all that. See your the petitioner had filed the I will repeat that. Petitioners had filed WPC number 2724 of 2024, alleging that the opposite parties were intending to evict them without giving them any reasonable opportunity of being heard. So, the case was disposed of on the very first day without seeking counter affidavit with the following directions. So, you have been evicted. No. Then, what do you want? But I want now has the order violated. Not because without money the disposable successful the opposite parties are extremely professionals the petitioner has submitted that in violation of the court order of the court, the parties are trying to evict the prisoners from the land, which is admittedly you are unauthorizedly occupying. But that apartment, there are some five taking interest in significant. Who are in occupation of the land in question, in respect of which even a civil suit is pending. That's all. They read it next. On the result of the court's order dated 7/2/2024, it is manifest that the said order was passed on the very first day when the petition was taken up, without seeking any counter affidavit from the other side. First off, in my opinion, no case of intentional disobedience of this court's order is made out in circumstances. Contempt proceeding you talk. Yes, item 41. Item 18, my lord. In which doubt the matter order has not been complied, my lord. Item 18. So which order? This is only 26th chapter of Shildak of Procedural. It will come on 25th. 25th. My lord. Item 21. Which chapter next to the last chapter and 14. Direction of the order of the copy of the contract is the accounting number. Solved matter or must be yes. You are not interested. Why today? My the person has been submitted to the accounting. Given these are services. These relate to pension or service. Yes, what, how much time do you pay? After vacation, after vacation, 25th. By 25th, it must be clear. Just now, basic please pay your office. They should issue authority slip. When was that sent? And when was the sanction order sent? 5/7/2024. It is the case of the. Yes, there is no documents to that support. Officials of the state. So the case on behalf of the officials of the state of Orissa that sanction order of additional pensionary benefits has been sent to the office of the Accountant General on 5/11/2020, 5/7/2024. So stop. Why don't you give him sanction order, Mr. No, they have to take action. No, but they don't have a sanction order. They must be having. I give you the commission of the pension number every tax bill. Next. Okay. See, whether you are party or not. All right. Have you filed any so-called reply? No. All right. I am directing the accountant to appear. Well, now, doctor, there is no question. See, there was no by this court. The only question is whether you are saying that you don't have any knowledge of communication. You have knowledge. Not very well. You have knowledge. Question. So, doctor, yes, don't take it. So the copy of the content of the all right. We'll see. I'll text it within the road. We'll be sure. This matter on 25/7/2024 or 25/10/2024. On which day the Accountant General, what is the office? Accountant General A&E. Accountant General also died. He is the party here. You want that the person who is alive should be sent to jail because we cannot send him into jail. What fee are you taking? All right, just a minute. The present accountant general name, what is his name? You are now continuing up to G Sahu. The present you attend with G Sahu. Presently G Sahu. G Sahu. Accountant general G Sahu shall be required to file a SOCO reply as to why contempt proceeding be not initiated against him for not issuing authority slip soon after the sanction order was passed. So stop. He shall also be required to inform this court as how much time does it take for the office of the accountant general to issue authority slip after the sanction orders are received. So stop. Open the toilet. It's open. Mr. G, it has been informed by learned counsel representing the accountant office of the accountant general that at the present accountant general is Mr. G Sahu. D Sahu. D Sahu. So stop. Let name of D Sahu. Let Mr. D Sahu be included as opposite party member so and so. That's all. Let the registry carry out necessary formalities. Yes. So now we have a party. No. Someone is right. No. This is what we wanted. No. Yes. You want him to be honest. All right. Title 42. Title 42. As for other whether you haven't complied or not complied with not showing the directly to complied with. No. That was the order passed and order was asked and taking note of that we must see directly that to finally compliance because improve violation. There improve violation that we will see that directly. Willful very question on willful. Let me see the order. Order violence, consent application, page 17 page 17 paragraph 9. We are speaking reason. They have passed that law, but not informed in the order. Second level. Again, the same order passed in the earlier one. There is a free for consideration. Which I applied the amendment and the second time and that was set aside, specifically directed this amendment specifically directed that the law decided in the case of Susan taking that into account, you have to pass an order. They have not passed the order, Susan not be restored. That is one party. Entire person. And that also order see file in this case. So no, in WPC. WPC issue as per order 9/2022 and was on disclosure in March 1st March 2024. Whether any affidavit was filed. Notification issued in August 2022. Used a very long time. The petitioner has alleged disobedience of an order of this court dated 1/3/2024 passed in WPC number 24234 of 2023, whereby the opposite parties were directed to dispose of the whereby this court had rejected had caused an order dated 9/5/2023. Yes, yes. Whereby the petitioner's representation was rejected. To stop. The court had further directed to consider the petitioner's case afresh is in accordance with the provision under CS Pension Rules 7 and 66 and the law laid down by this court in case of Sushant Chandra Shahu. Reported in Para 7 years. Sushant Shahu was 60 Para 7. Dated 6/5/2022 in W number 14718 of 2015. Stop. Next, the petitioner's representation has been rejected by it is prerogative not in dispute that in compliance of the said order, the petitioner's representation has been disposed of. Yes, by order of 4th July 2024, keeping in view the rule 7 and 4 of 66 of Orissa Civil Service Commission rules. But Sushant Chandra case has not been disposed. Taking into account the pension rules, so and so. Learned counsel appearing on behalf of the petitioner has submitted that that passing of the said order does not amount to true compliance of this court's order, whereby the opposite parties were directed to consider the decision rendered in Sushant Chandra Sahu, bracketed Supra. So he submits that the order does not mention the name of Sushant Chandra Shahu, and therefore a case of deliberate disobedience of this court's order is made up. Stop. Next, I am not convinced with the aforesaid submission. Stop. An order has been passed in compliance of the court's order, legality of which should not be gone into in the present contempt proceeding. The petitioner is at liberty to question the correctness of the said order before appropriate forum in accordance with law. The contempt proceeding is law. Submission in Sushant Chandra Sahu case, rule 7 and 66 have been discussed. That was my trying to convince your lessons that the Sushant Chandra Sahu case has not been. I am satisfied with your submission. Then I cannot quash that order. No, I cannot quash the order. And now they have passed an order. So if it is very difficult to hold that they intentionally did not refer to the decision. So they might have committed a wrong mistake, but not intentional violation. Deliberate violation because the earlier appeal also on the same ground was rejected and the order was set aside. The second round of late position. Anyway, I am respectful submission before that WAG. Yes, whether complied with or not. I will take inspection on the process whether it was earlier taken up. Yes, on 29/2024. Let me see the nature of order. No, that will accordance to yes. Same Sushant Chandra Sahu. Yes, other people I am seeking time. Let people what order held in Sushant Chandra Sahu. That in my learning first saying that Sushant Sahu case is held the pendants of the criminal case of Departmental one is entitled to full concern, but rule is otherwise. Rule states. Rule has been interpreted and it has been held that unless comprehensive taken in the criminal proceeding, you cannot say that the dismissal proceeding is failure. The rule is very clear to that extent. In the explanation under the rule, it has been specifically worded that we are supposed to wording the also the government is put up within the court, so that also. Will come on the next day. 25th more. And meanwhile, you please examine. All right. If they are intentionally violating and trying to avoid what has been held in Sushant Chandra Sahu, then the consequences may be serious. Hello. Just examine Mr. Kutia and advise them. Item 25. When the last occasion that found the complaint for the vote, and we are also directed me to go through it and justify my entitlement under the order number. Okay, we will actually kind of so quickly paragraphs. Let me see the order first. And proceed. 25. Page 19. Just a minute, sorry. And it's one in the order. Just a minute. Yes, sir. Annexure 1, page 9, and relevant page 19, paragraph 7. Yes. The undisputed fact being that the petition is continuing as a vulnerable cause under the Office Statute number 2, and we have already been extended the revised page 12 rules 2008 with effect from 9/9/11 in compliance with the order dated 31/3/11 passed by this honorable court in WCC number 24, and as such on being regularized with effect from 9/11/95. That is very important. Date of regulation 9/11/95. The petition has already been extended with the regular scale of pay of rupees so and so with effect from 96. Admittedly, the petitioner has not been paid revised pay scale rules 98 applicable to the petitioner with effect to 1/1/96 in 31/5/2005. So also the what is the direction? Paragraph the relevant and I will go to the opposite person. Revised pay scale rule and to with effect applicable to with effect from 1/1/2006 to 9/11. Then we will actually see paragraph 9. Which is almost an universal rule in public services, and employee start with a particular pay, then journey through the to reach the highest level that is entitled to someone as senior. The question has basically three elements. The first is the minimum pay, Our initial pay in the placement, the second is the periodical increment, the third is the maximum pay with the placement. And employee starts with the initial pay in the placement and gets periodical increment, and which is the maximum ceiling in placement. Each stage in the placement starting from the initial pay, ending with the ceiling placement, then they apply to an employee, they refer to basic pay of the employee. This is not the paid increment, I will give so you lucky. Then paragraph 10, let's say I have page 22. Therefore, taking from the top, therefore taking into consideration the qualification and also subject rendered by the petitioner, the service has been regularized and he has been granted with the scale of pay, so free service has been regularized, service has been regularized with effect from 995. Then paragraph 11, relevant question, paragraph page 24 will also be there. Start at page 23, relevant question at page 24. Therefore, when the petitioner claims priority with regard to prevent personal use maintained in 2008, as far which is counterpart with the state government, in view of the rules 1838 of rules applicable to the state government, this court is of the considered view that in view of the service rules applicable to the petitioner, he should have been extended with the benefit of revised personal rule 98 and 2008, which effect from 1/1/96 to 1/1/2006 respectively. The same having not been extended to the petitioner, the opposite party has arbitrarily, unreasonably, and contrary to the provisions of law. By virtue of the order passed by this court, the revised scheme has already been applied to the petitioner, so again with effect from 99 level. Then, paragraph 12, which is the operative question. Paragraph 12. 24. In interested fact and circumstances, this court is of the considered view that the petitioner is entitled to get revised pay scale rules 98 applicable with effect from 1/1/96 to 31/12/2005 and consequential revised pay scale rule 2008 applicable with effect from 1/1/2006 till 89/11. As we have already been granted that benefit with effect from 99/11. Now you have to say what is the 99 benefit I will, that is as page 26 of the affidavit, madam. The following the council of court that is at payment in the state of state with respect for month with DO, HRA and other allowances as admissible to state government employees with exact immediate effect. So this might pay DO, HRA and other allowances have to be paid. It is available under the fiscal rules. These have been paid from 99 level. My number name is there. The number 21. 27. So I have been given the benefit from 9/11. It is for the previous period from the did you take this pay in your objection? Objection, madam. Objection. What they have done, the breaking service, they are giving it a breaking service. You can go ahead committee, Mr. Paragraph 10, madam. Different thing. Compliance of the order is one part. Once I have paid, it's from 1/1/85, but sorry, 9/9/95. See, they can do legalities. But that is contempt or not is the question. Yes. But if there is any specific direction that has been violated, the matter is different. If they have wrongly calculated, then you can question the calculation. Inappropriate to say. So now I understand. Once the state says that I am regularly and directed me to pay the scale of pay in that day. Now thereafter it is not open to them to make a breaking service and make payment. That is available in the record, madam. What we have done. Once the I have to take that. Breaking service issue was there before the court. No, that's it. So the third thing they are coming with. So you can challenge that. Breaking service was not the issue which has been adjudicated upon. The court allocated it is adjudicated by the regulation between the paragraph 7 level. Yes. Once I have been regularizing that day, so thereafter there can be breaking service. Then because you are regularized with it from particular Yes, not being breaking service, breaking service. Because they say that I am not regular, my regular is service, and the particular thing that my regular scale of pay was paid for 2011. My service was regularized from 95. They say that no, you have been regularized from 2011. So already you have to make the payment from the date of regulation. Yes, actually coming from the paragraph, let me see the order. Paragraph 7 again, paragraph 7, paragraph 12. Yes. Because all is specific, very clear. This will have to be implemented. Yes. 24 madam. In view of the aforesaid fact and circumstances, these court is of the considered view that the petitioner is entitled to get revised pay scale rules 94 to 1998 applicable to 1196 to 31/12/2005, so whether this has been done or not. With the baking service. The baking service done was not considered. You can challenge that after the order was passed, after the order, they made the baking service. Therefore, you can question that aspect. Because we follow order only that is the final account say. That can be illegal. That is not contentious. The only order is simply that it's just one word in Maya. Then we can to implement that is implement is not being paid. All right. And we have to say the rate is available under the and according to the pay, but other things are not entitled to. So, see, we don't order. Therefore, I am observing repeatedly that their action is illegal. Yes, but actually, whether the action violate any order. So no, I'll not do anything. I'll not pass any additional order in this case. I'll give you liberty. But they're not issuing any order now. They're not issuing any order. And therefore, you don't have any season law. Then argue this. But because they are not issuing any order, therefore, the petitioner in the present contempt application has alleged disobedience of this court's order dated so and so past in WPC number so and so. Operative portion of which reads as under paragraph 12. So, when counsel obtaining on behalf of the petitioner does not dispute that in the light of this court's order, the payment but he has submitted that the amounts have been wrongly computed and they have wrongly treated the period of which period written service. Every month they are looking normal every month. The wrongly treated 1 day in each of the month. From that relevant year is from 1196 2005 2005 as breaking service, despite the fact that 2011, despite the fact that this court has recorded specific finding that the petitioner should be treated to have been regularized with effect from 1/1/1996. 1/1/1996 also he submits. Regularized 95 number. That's the finding. 1/1/1995. Sorry, sir. Paragraph 7. 9/11/1995. Post office submits that there would have been no question of break in service once it was once it has been held by this court that the petitioner is to regularize with effect from 9/11/1995. Stop. Next. I am, however, of the view that the action of the opposing parties does not come within the scope of contempt of court, as the said action cannot be said to be intentional disobedience of this court's order. So, if the petitioner is not satisfied with the computation or taking some period as breaking service, he has a remedy of approaching appropriate forum for reversal of his grievances. Stop. The issue of breaking service was not a question addressed by this court in the order violation of which has been alleged. Stop. In such view of the matter, while granting the petitioner a liberty to approach to review his demands before appropriate forum, the contempt proceeding is dropped. Other benefits under the rules also are not different. Other benefits. Other rules. Anything you can do. Actually, the subject matter. Other benefits. Item 26. Actually, the subject. That's my focus. Yes. 26.
Objection question number 3.67 of 2007, pending before capital C 2007. So, my court instruction of the government.
So, it was also taken to 22, so that I can the program of the communication that we additional C of law. So that matter was hard, but judgment had not been pronounced. I only obtained instruction every time intended to pronounce the judgment or not. You see, the additional sub-collector from additional consultation officer in the Padam. No problem. We have contempt proceeding. I am initiating contempt proceeding. At 2 p.m. At 2 p.m. I shall initiate contempt proceeding against him. Huh? Today. I will today at 2 p.m. Because the specific obligation last order 28/6/2024 that if not fully complied with, the court will presume that violation of this court's order is intentional, warranting exercise of contempt jurisdiction. If despite this, the order has not been met and I do not take any action against him, the people will start losing faith in the system. 2 p.m. Either it is complied with or he shall appear on the next date. At about 27, which is like some of the principle and most of the part of the order has been completed. Only one part is left to us, that is what with regard to the suspension period from 2016 till 2017, and that is to be concluded. So 25th will comply that 25th by way of past indulgence. The matter is adjourned to 25 10 2024, giving a chance to the contemners to ensure full compliance of this court's order. It is made clear that the court will be left with no other option but to proceed against the contenders for intentional disobedience of this court's order. Yes. I reply affidavit will be brought up. Here, accountant was a party, but the action against the accountant. All right, then you are fair. From Tribunal, I have been complied plus we have been taking something had done such
May I please your lord, sir? I am VC, my lord. The order dated to 7/8/23 has not been compliant. The last opinion, the State Council has sought for time to obtain instruction in the matter.
Your power has been for encroachment. So it already complied with the Mahapatra. Complied with item number 30.
My lord, I have not received an
You will get,
complaints affidavit, my lord.
you will get a copy. From 30, my lord, the order letter 1910, 2020 was not been considered. On the last October opinion, this case, that I like the in which case, this is in that case, well, and what are the case? In which case, no, it's not the case. This case are not been restored. Or understood, all right, make your submission. Then along the order 19 the last year of the last order 6/9/2024. And another time was granted 4 weeks time to comply the same. But till then, it has not been completed and you will have to get the order 14. Page 14. Yes, 1/4. And the resolution fixes time disposal with the direction to the opposite party that failed to consider and examine annexure 5 consider and examine the it's very difficult. Have you considered and examined? But there are you will say find a suit pull. We have filed a suit, the suit is now disposed of, she has got the passage proof of, the claim is that who doesn't have any passage proof about, you some something of suit, because I have got this passage proof, not related, that was, yes. The petitioner had approached this court alleging encroachment caused by opposite party number 6 upon a piece of government land and thereby affecting our access to the main road. The petition was disposed of with a direction to examine the petitioner's representation and petitioner's representation. Next, Mr. Samantraj and AG appearing on behalf of the contemners has submitted that in respect of the same land in question, the petitioner had filed suit. Civil suit. So during this year's number 598 of 2021. Which has been decreed when was by the government dated 21st of September 2023. Dismissed. Which has been dismissed by so and so. Stop. Dismissed by order in it was 21st of September 2023. 21st of September 2023. Stop. this said aspect was not, apparently this said aspect was not brought to the notice of this court. Brought to this court's notice. When had you filed the writ petition? It's on filed on why should not be some action initiated against you? I will take respect for his initiation of action, you receive instruction. That similar type of action there in the suit or not, I have not. That is the reason I have not disclosed that. The said aspect was apparently not brought to this court's notice. Stop. In the court's opinion, no case of disobedience of this court's order is read out. Contempt proceeding is dropped. Item 31. Now in that case, which item is that? That is not listed. So that has not been listed. Actually listed on 20. Why? You see, you are a lawyer. You said that is why did you come to the court? That now difficulty. So sorry, that now difficulty can say alternate. So salary concern has been stopped due to convenience of the content. Give her that. Give her. That's right. Please look into the grievance. That old fellow, he is also suffering from you come on 25th from even if your case is not listed. From some of the 6/9/2024, which time allowed the level of to seek instruction and find complaints of the statement to that action has been taken after the recall order passed on 9/2024. So the time of compliance, the controller conference ability on ability to find the order is passed and return to the required. Order dated 9/2024. So my last question directed the State Council. So any action after 9/2024, once the conference state order is recalled, so the action is to take it after 9/2024. So what should do that? Yes, after 9/1/2024. But then we also called on 30 reports. I will obtain instruction because which is instruction that the order was not. No, it seems that it is the case that in compliance with this court's order, some order was passed. Yes, no. That order was recalled. So that order you were required to pass the order. That I was telling you your case. So sort of should be admitted that it comply the order because of the practice. It will not comply the order in the petition. So that is the petition. On behalf of the Byland AGA, this matter on 25th to comply with this court's order dated 6/9/2024. Yes, item 32. 32 minutes and the last question, your lordship directed to file the complaints. The lordship was disposing the restriction directed to by passing the order of dismissal to consider in the light of the Rakeshberry. Remember the Rakeshberry case, the government has moved the apex court, the SLP was dismissed, thereafter it was implemented by brought to this submission. That was the order in the lordship in the reproduction directed specifically, and the government also or I will admitted that which in such way the additional standing council submitted that we will be no objection in the event which should be reminded to the appellant to consider the matter in the light of the law laid down in the Rakesh Purohit case. This is the order of the Honorable Apex Court. It shall be dismissed and then implemented in Rakesh Purohit. The CDM has not so written to the state government to implement the order. They requested for some more time, you know. For implementation of the order of this court. 25th. Yes. Out of implementation. Item 33. Non-compliance of order dated 17/10/2023 order. That was posted in the last edition, the government has taken time. But instruction allowed. Procedural that will also item 6924 to obtain instructions. And we don't want to notify, I will definitely do. Where is the order? Order is $11. And very important is manner. A petition also, I think for a petition, that is for the supply to somewhere. The order will be very possible that complete immediately 4 months. Now it is 2024. Start, at least you should have filed an application for extension of time. And as on date, please ensure that all such matters which are pending, all such matters, there should be someone to review. Maybe your officer who is the I haven't expected to come. Take care more. See, not only you should have a game to ensure that all the cases, this contempt cases, or even otherwise, when the orders have been passed, they are to be implemented before contempt application is. All right. So there must be some mechanism in place. Otherwise, this generate unnecessary litigation. She just is sitting from morning till unnecessarily. So you can see out of 100 cases, there may be one case in which a case of disobedience is met out, or but in each and every case, if you don't comply with the order, then that is unnecessary litigation. So you can convey to your chief secretary. I don't know what is your litigation policy, but why should not you give priority to these cases? So why should we wait for a contempt application? And so far I am very good. Now, the moment a contempt case is filed, I may take them seriously and initiate action against you. It is only that so far I have been ensuring the implementation of this court's order. Now, if I see that in most of the cases you are doing it, then you shall have to face consequences. And you should convey to your officials. Yes. Problem. Yes. No? 95th. It will have to fall. Code manner. Contract compliance for 2023 manner on management compliant manner. And allow technically taken time to file compliance application. Where you will also send yourself, but it's not also direct something instruction. It's possible that Kendra Padam. Allegation is that there was some persons including government line of 13 days in and You get from the house law, that is the allegation. I think the loss is the creation direct to examine the recent data will take it to some. So the research notes I can take research notes, so I think. See, these matters I am not in time, Mr. Sorry. For removal of illegal encroachment, I think there were thousand cases filed. Moving illegal encroachment. Illegal encroachment is a serious matter. The person against whom we are making allegation, he is required to be heard. And under the threat of the court order, they cannot be removed. They have a right to be heard. They had a right to be heard. The petitioner in the present contempt application has alleged disobedience of Court's order dated 21/12/2023, passed in WPC number 1877 of 2023, which was disposed of without issuance of notice. First of the petitioner had alleged illegal encroachments caused by private parties over the government block. Stop. The private parties were not. They were private parties. They were not noticed. Stop. The petition was disposed of with a direction to opposite party number 3 to examine the grievance and take a decision and remove the encroachment after providing reasonable opportunity of hearing to the encroachers to both sides. Stop. In my opinion, in the facts and circumstances, no case of deliberate disobedience of this court's order is without contempt proceeding at all. Yes. Good. Item number 35. Yes, what was the order? The one. What is the order? With the direction to dispose of the petition was filed by the petitioner before the concurrent orders. What was the petition? His prayer was to appoint the petitioner against the approved court of laboratory assignment under the arrest scheme was. That's why his application was. Item number 35. Where is your representation? You have filed a representation. File a representation, whether representation we had filed or not, it is not known. One. So unless we saw, so where is the implementation? Not right. The petitioner has raised this legal call and score dated 19/5/2023. Passed in WPC number 16477 of 2023. Whereby a representation filed by the petitioner was directed to be disposed of. For the petitioner has seven hundred, representation valid, 600. So I have had on 1722 valid. 17.8. That was one, 17.822. Annexure 6 valid. Annexure 6. There is no annexure 6, but yes. Petitions. Who had received it? Who had received the representation? What is the date? 17 valid. What is the date? 17 is date. 17. We wait for an inquiry, whether we will find the representations or not. Taking instructions. I have representation. Representation which representations which were brought on report by way of Annexure 6 series, which were addressed to the Principal Secretary, Department of Higher Education, Government of Orissa. Full stop. The Principal Secretary, Department of Higher Education, filed an affidavit as to whether any such representation dated 17/8/2022 / 3/11/2022 / 27/2/2023 was ever filed before him. Anymore. The court is inclined to cause an inquiry as about the circumstance and which the petitioner on the order for disposal of representation on the very first day when the petition was filed. To be ready for action. File your affidavit. Was at around 25. Section 36 provides the direction for disposal of utensils. Some of the instruction whether we utensil will dispose of or not. Yes, 25th.
They say that subject
Then 37.
no, please, madam. On the last occasion, 6/9/2024, the Government Council is to take instruction manual. The manual is directed to take instruction manual. Regarding the compliance of the order. It takes 2
The instruction is coming up now. And 16 years from captain was to directed. 24 was to, when I will see that it's compliant by way of last indulgence. The matter is adjourned to 25/10/2024 to enable AGA to seek instructions and file complaint / so-called reply. Yes, item 38.
last occasion, and senior is produced the document showing that the sanction of the original pension by the authority. But instruction that which was specifically directed by the honorable is actually found to remove the original pension in favor of the petitioner as due and admissible. My lord, so they have released sanction that is my lord. One is my lord, they have issued the sanction, but the amount they have fixed, that is wrong. That's subject to challenge. Will also indicate that the petitioner has given liberty to challenge
the compliance of this court's order, violation of which has been alleged in the present writ application. Admittedly, the opposite parties have OP number 4 has issued sanction order. From current counsel appearing on behalf of the petitioner has submitted the computation of the amount is incorrect. So, next, the correctness of the determination of amount cannot be gone into in the present contempt proceeding, as in the court's opinion, contempt proceeding. Stop. In the court's opinion, no case of intentional disobedience of this court's order is let out. The contempt proceeding is dropped with a liberty to the petitioner to raise the issue of correctness of the computation of amount before appropriate authority / forum in accordance with law. Note 39.
This is the second contempt.
No second contempt, first contempt. Either your contempt will be dismissed or your contempt application or the order is complied with, person is punished. So there are 3. No second. First is enough.
The opposite party has not complied with the
Let us keep the order.
that is the one.
Connection 1.
My lord, when it is actually
13.
The petition is applied for the posted nursing officer, my lord. But which comes from the petition, registration precedent certificate. So on that basis, I filed the same application before the lordships, my lord.
What is the direction?
That is 13 last paragraph, my lord. Considering the sanction made by the legislature.
Just each item? 39. Item 39. Contempt 4/7 of 2024. Which page you are referring to? Annexure 1. Yes. Last paragraph. Yes, what do you order? Considering this reasons, according to the respective practice and facts of the present case as well as some which for the financial or direct for the position to activity of some insurance or registration certificate. Some what has been violated? I have communicated silent my life, so still not being silent my life. So by which I am able to get the job. Tax election commission, we have to get that here. It's an independent body, that's an issue of this in this way. No, no, the direction was to approach opposite party number 1. If opposite party number is was it's a staff selection committee, subordinate staff selection committee. It's the independent body is the council of lawyers. Like the public service commission, staff selection commission, that's true. They are issue notice. Yes. Oh, yes. 6 weeks, 8 weeks. Yes. Oh, yes. For order cycle of 40.
Mayor Rashid, as per the noting, the notice has returned that answer as they have relocated their office. Your Lordship will take steps.
What is this about?
Lordship, kindly put the glance at annexure 1, page number.
Where is the order?
Annexure 1 in Lordship.
Extra 1.
Para 18B, Your Lordship.
What is the date of the order? Who are the components?
Your Lordship, it is ORIDA, Odisha Energy Development Agency. The date of judgment is 27/7/2017.
27/7.
2017.
Managing Director.
Lordship, Mr. Mishra is the chairman of the Rupa Mishra, the chairman of the Odisha Renewable Energy.
Officer is what?
Chairman, Your Worship.
Is he an IAS officer or? IAS. IAS officer. Yes. Don't have it. The Odisha is also not, petitions be communicated by the registry to Mr. Gopal Mishra. That he may not be there for France. Rupa Mishra. She may not be there. She was a chairman of it. She should have told Chairman Orida. What do you mean? What do you mean? Tell me. I have to instruction. Tell me by to him. Huh? Which matters will be listed from 25 when the chairman or address shall be required to state as to whether this court's order dated so and so, passed in so and so has been complied with or not. Item 41. What happened? When the contempt petition, what petition discussed? All right. Yes. Item 42. There is a direction to comply with the order of demolition. But internal the so no content I am not a practically agree. So we need to do all right. Conduct the approval. At the movement of contempt in the present contempt application. An order passed. I am for the 22/6/2022. Part in WPC number 10795/2020 has been alleged. Stop. By the said order, the court had disposed of the writ petition with a direction to the Cuttack Development Authority to remove the encroachment. Unauthorized construction. Sorry, it appears that the aggrieved persons had opposed this court. This court and WPC number 24, wherein an order of stay has been granted. But already directed dispose of the offer 7 wherein an order has been passed for disposal of appeal. Appeal number 17. 20 pending before. And then we come secretary house member. The petition in circular of the matter seeks permission to withdraw this contempt applications with the liberty to pursue his matter before the appellate authority. I will answer the appellate authority. Yes, yes, sir. I don't know 42. Sorry, drill. Draw. Yes. 43 minutes permitted to I don't know, sir. And then, when complaints of the error, translated in division like single judge mallet. Single judge order mallet passed on first order passed in 9/4/2014. Thereafter, also modified and passed order of 18/5/2016. Whenever modified means I understand, but what is the order? Order. Sir, seven on a page, 13 minus and six, page 15 minus. Contempt petition 1620. This one. 1620. Yes. Person will ensure the modification of the judgment by way which go after direct the above authority. Sir, where is the order? His page 10 of the contempt. Sir, not well. Review order page 12 now. Well, I have 13, page 14. Page 12. Page 12, last question of the order is page 15 order. Page 14, and direct to the contender to the 6 suits. Thereafter, they filed and confirm this in the judge order manner. When the court, they also informed that they filed a SLP before the Supreme Court manner. When SLP number manner, since the SLP, yes, manner. In 2024, it has been disposed of, and the Honorable Supreme Court directed to pay 15 lakh compensation. That compensation amount has already been disbursed to the executive engineer, and by 10th of October, it will be released to the account of the petitioner. I have reached the SLP or since SLP, we are not inclined to the High Court and its finding and facts. Accordingly, the SLP special litigation will be dismissed. Already the compensation. So, Mr. Counsel, the order of the court has been modified by the present order. They also compensated 15 lakh only in appointment. That means what they he said he has never been appointed. The court has said that he will be entitled for 15 lakh in the appointment. So we'll get that. Compensation. And what they found in time to litigation. Oh no, it says that pay an amount so and so towards fifth and final payment as compensation in lieu of appointment. In lieu of appointment means instead of appointment. All right. The petitioner has alleged disobedience of an order passed by a coordinate bench of this court in RB PET number 290 of 2015. So the said order of the coordinate bench was challenged by filing a writ appeal, which stood dismissed on merits. Stop. Later, the Letter MS Southern Electricity Supply Company of Orissa preferred SLP against the order of the division bench, giving rise to SLP, special league to appeal bracketed C number 15789 of 2018 19. The SLP has been the Supreme Court, while not interfering in the impugn order passed by the High Court and the findings of facts, has held as under in its order dated as observed so and so as under in the order dated 2/9/2024. So when counsel appearing on behalf of the contemners has submitted that the petitioner shall be paid his amount of compensation by 10th of October. 10th of October. Stop. This matter on 25th. Well, it was 45. So 45 and 46. Plus, I find that the complaint for the order compliant with the voting 45 and 46. Item 47. Is survey in the Luxembourg withdraw.
Yes, ma'am. We both the process, ma'am.
Item 49. No, it is bus. Under Annex 3 number, they have 19 and not in complied with. Remember since the final the petitioner approached this honorable court for regulation of service, contract was not renewed by the approved parties. Proceed cancel the order under Annex 3 Active 19 manner. This is an interim order passed by this honorable court on 17/7 order. The writ petition is still pending. It's pending. This is matter wrong with publication investigation. Here, because of the person with contempt petition will be heard along with that. All right. Since 2000, considering the above and information, this court narrows that with the petition discharging his duties, he shall continue as such till the next day. That the dishonest. So wonderful. Like since 2020, I am out of service. Lost can recommendation for appropriate bench. That at about 50. Imagine in this case, opposite party is to the only road to access the petitioner's land. So petitioner approached this honorable court, wherein honorable court directed to leave the other side enclosed the land. And you approach the High Court. That is there was no authority, no other authority for such redressal of such grievance. Now, this court might have directed you to make a representation. Then this honorable court directed to meet 10 feet road and do the construction. Who will go to whom? Very well. Now, I will put in this contempt page. Yes. is melon. They have filed a show cause, but in that show cause, the which they refer to as road is actually a drain, 4 feet drain, and that does not reach till the main road. It stops behind the school boundary wall. Now let my submission in the on the last date of hearing in para 4 of order dated 13/2022. In view of dispute raised by Learned Counsel for the petition, Mr. A.K. Mr. Learned additional is directed to take instruction and file an affidavit as to what way a road of 10 feet width has been left by the authority for the user. That is beyond the scope of contempt proceeding, Mr. Counsel. We are not here in the contempt proceeding to resolve disputes. That someone has violated the court's order or not. That's all. Yes, my lord. That is not a road and it's a drain. There is a demarcation proceeding wherein they have stated that is full. We will not go into those aspects in contempt proceeding. The petitioner filed a petition before this court alleging that who were the opposing parties who were encroaching. Would you say that government is constructing by dispensary center by opposite parties were encroaching upon their private land and road of 60 feet connecting warehouses. So, the said with petition was disposed of without issuance of notice requiring the executive engineer to get the land demarcated. And further that if in any manner the private land of Krishna was getting engrossed, the same should be left out of the area of a construction of a dispensary or dispensary. So, when counsel appearing on behalf of the petitioner has attempted to convince this court that the compliance of the order dated 8/1/2021 is not in its letter and spirit in as much as that 10-feet road has not been 10-feet wide road has not been left for use by the petitioner. So, it is apparent from the materials on record that there are certain disputes about the actual position. So, such aspect should not be gone into a contempt proceeding. So, contempt proceeding is dropped. So, the petitioner shall, however, be at liberty to approach appropriate authority of the civil court competent jurisdiction for redressal of his grievances. Their grievances, not one. Yes. No, there are more than one petitioner. No, one petitioner. One petitioner. One petitioner. It is mentioned petitioners. Petitioner. Dropped. Yes.
Item 51.
Yes, sir. Last you wanted to know the name of the chairman, so but I didn't make a Hemant Sharma. I was Hemant Sharma was. Hemant Sharma. No.
I don't need your 51. My lord, the order of the summary court, dated 2018 was drafted by the authority on the guise of that an appeal is filed. But the Honorable Supreme Court has categorically held that we are filing an appeal not operate as a stay unless and until an interim order is passed. From 2018 onwards, let's kindly turn to page 20 of the Contempt petition, last page, wherein the Honorable directed with due respect to the appropriate decision of the Honorable Supreme Court to the accused that even the contractual employees are entitled to the principles of equal pay to equal work. Although the petitioner is being paid equal pay, but she is not paid the equal due, she is actually like it's 20, paragraph 29. of the Contempt petition, my lord.
Page 20, yes.
I will go to my lord, paragraph 29.
Yes.
With due respect to the appropriate decision of the Honorable Supreme Court to the accused that even the contractual employees are entitled to equal pay, although the petition is paid equal pay, but she is not paid equal due. She is actually like any other teacher of the university. Therefore, she is entitled to the DA, the availability of other teachers working in university, increased from time to time, and as such, entitled to differential pay. And the petition is entitled to differential pay, there is no provision to allow the HRA to be employed appointed on contract basis. And the same has not been proved by the petition. So she is not entitled to HRA. In terms of discussion, the petition is because of the direction of the movement to pay the differential pay. The petition will be approved from the date of the October calculation of the same. I have filed an intimation for change of the content number 1. It was initially Bhattacharan that, now it is Kancharan Bali, register of the 7th University.
Yes.
No, Revenue University, man. Revenue University, man, it is to.
It was for the it was for the university. But this is not issued.
No, it is issued.
Where is your idea?
I am a member.
Item number 446 of 2023. This application has been filed for amendment in the contempt application for implement of contempt application so as to impede. Whose name is that?
Kancharan Bali, register Revenue University instead of Bhattacharan Das.
No, this is not substitution, this is addition.
Number 1 is register Revenue just again transfer. Now the contender has joined. Who's Kancharan Bali first.
So he should be removed. According to you, Pradhan should be removed.
But she should be there.
This should be, therefore, I am putting the question that someone has to be added.
Yes, madam. Added, madam.
For implement or what is the name?
Kancharan Bali.
Kancharan so and so. The present registrar Ravensa University Cutter has for the party number.
Item 1.
Party number.
Yes, madam.
C.
2, madam.
So, considering the facts and circumstances, this application is allowed that so and so be included as opposite party number 3. Let necessary corrections be carried out by the registry. So, issue notice
This one.
1 week,
Almost
6 weeks.
Item 52. New complaints. Now, the order dated 27th May 2022, passed by the Supreme Court under Annex 1 has not been complied, my lord. Now, the direction was the opposite party number 1 is to take a decision on the time university next city level.
as requested. Yes.
Item 53. Criminal ransom payment.
Why should I on time in every case?
But I think my lord will complain. Not in disposal.
But I'm not concerned with this. That's not the order. You see. Well, you come to pay the 18 lot. I'm not someone. So the first order of the lot. On 2/6/2020, in which the opposite party in the three was directed to pass applicable order. Within 3 months from the date of production of certified copy of this order given. And accordingly, the petitioner was submitted copy of this order. Why should I learn? Why have you not done it so far? This is 2020.
But so I have taken some instructions because they have some irregular, they are going to regulate that nothing to them. I have taken instructions.
This is essential matter, Mr. Counsel, but it seems to me, this is what I must remind you, that you filed the writ petition when? And the very next day it was disposed of, and in the contempt petition, you should notice. So without issues of notice, the writ petition was dismissed, so it is disposed of. And contempt petition, every procedure has to be adopted. No. As requested on behalf of my and AGL is this matter on 25th. 54. I will pardon the Lord, my son, not anything. But it's not anything.
Item 54.
May I please your lordship? Your lordship, requisites already filed, which may kindly be accepted.
All right.
Item 55. Item 56.
56, my lord. In respect of petitioner one, we compared the several petitioner 2 and 6, they are not compared. The lawsuit council order, letter 61, 2020. They are mentioned in the complaints affidavit. In para 8, the lawsuit council, value page 25. Para 8, value page 25, my lord. Internal complaints affidavit. Complaints affidavit, letter 6/22. Yes. We have did that the director officially had letters also intimated the authority Department of Employment of persons with disability related to the service to whether the decision to extend necessary benefit to the petitioner number 1 by giving part B scale to 50 CPC to the petitioner number 1, that the said benefit could not be extended for the petitioner number 6. And then mentioned that they requested the government on 1921 of India for the conference. We did they have not received. So for one petitioner, one concern, we receive all the benefit. 6 are not done. The discussion has been taken for all of them. We have actually been very, because of the government of India, we can find this, so we'll actually kind of see that letter. But according to you. Government of India. Well, Ministry, secretary number. Yes, rules for the government. Oh, someone is appearing. Mr. Bindisa Das was appearing. Huh? Mr. Bindisa Das was appearing. Thereafter, Mr. S. Das. What is ENIR? Internal. Huh? That is National Institute of Reliability Training. How meaning of the that is Government of India organization. Government of India organization. Every Government of India organization. Like that order. Another order is National Council. Paragraph 7, page 13. Now we go. Yes. Considering the rival contentions of the parties, this court finds the crux of the matter remains involving scale of pay to be extended in favor of the petition number 1 to 6, keeping in the fifth division in scale of pay, creating a complete session in the matter of 15 petitioners scale of pay, with the scale of pay being adopted in the fifth revised scale of pay by the media. Taking into consideration the entire aspects, this court is of the opinion that the petitioner have been made to suffer for their no access. Once petitioner are in particular scale of pay, even if it does not fit to a scale of pay under the revised scale of pay rules, it becomes the responsibility of the employer at least to remove the anomaly and not leaving the petitioners to the mercy of the others. In this view of the matter, and considering that the petitioner deprived from the benefit of treatment, the petition of their instance the people of detention and the impact on the concerned ministry has directed to take a joint decision on the demand of the petition and removing the anomaly as appropriate, but by completing entire exercise would be clear 3 months from the date of communication of the order. By taking decision, both authorities will also keep in view the allegations of the petitioners that similar benefit has already been granted to similar situated person in other autonomous establishments. Whether they have been denied, annexure, where is annexure Y? Annexure Y to the compliance affidavit. Now, annexure Y, that is at place, at post 12 manner, internal test 12, 32. The annexure Y. Last 3 lines, they requested the Government of India to take a decision. Therefore, it is requested that after financial conference of the Department of Expenditure Ministry of Finance, necessary order may be issued in this regard, we have to avoid any possibility legal complication, we have to avoid contempt of the Honorable High Court of Orissa. So their cases have been rejected. Why contempt? You can challenge. But that was rejected. They submitted to the Government of India. Last 3 lines. Last 3 lines. Yes. Where, which last 3 lines? Of the letter dated 9th April 21, annexure Y. Yes. Therefore, it is requested that after financial conference of the reading, yes, running the 32, internal conference affidavit filed with the annexure Y, that is. Yes. That is 19th April 21. Yes. Last year I will actually times. What is the date? That is 19th April 21. So they will be speaking of where after 15. Sorry, 13. Next page. Yes, that 13 is never 19th April order number. 13 order, 13 is 13 is 13 is the main order. In 13 merits of each of the cases have been considered. And so far as election time says, so far as one petition that they given, other petitions are there mentioned that did not consider. Not consider. Not consider because the ministry has to consider. Civil number 3, election time see. So, Navin Prasad, Regime Council endorsed the recommendation of the Honorable Committee. Otherwise, Director SB not to consider part B scale, not to consider. all the cases not to consider, and that is 2021. And thereafter, refer to, I want to the thing. After the decision. The other contempt of proceeding, they have, and both ministry and the director letter will take joint decision in the matter. So whose case was considered? What do you mean? So voting, respect of voting, this was this communication was made. Well, 19th April 2000. Therefore, they mentioned for 8 of the state, they were already concerned, they referred, there is no question of reference. They declined. Why are you making this submission? See, they pass and speaking on in respect of one they agreed, and accordingly they made recommendations subsequently. Other cases they declined. What would I challenge there? They already saying the director, both the director and the ministry concerned, the joint will take decision to remove on that. Only the director, therefore they refer to the substance letter, they refer to the government of India. The petitioners in the present contempt application have alleged disobedience of this court's order dated 16/1/2003, passed in WPC number 5052 of 2003, whereby this court had disposed of the writ petition with the following direction and observation and direction, paragraph 7. Stop. Compliance affidavit has been filed on behalf of the opposite parties, wherein speaking order asked by the director bracketed officiating, Swami Vivekananda National Institute of Rehabilitation Training and Center, dated 8/4/2021, has been brought on the call, from which it appears that after considering the cases of the petitioners, in case of petitioner number 1, in the case of Sri Dhuti Krishna Rao, he was found entitled for a particular scale of pay as per 5th recommendation. 5th CPC sees the recommendation. As regards other, from the said speaking order, it appears that SV NR Jobi declined to grant the same benefit for others. And counsel appearing on behalf of the petitioner has submitted that it amounts to disobedience of this court's order. So I do not find any case of deliberate disobedience of this court's order being made out since apparently the cases of all the petitioners were considered and only petition number one of the writ petition was found. Only case of petition was found to be the only petition was found to be entitled to the revised scale of pay after removal of anomaly, under 5th CPC. Stop. Next, the contempt proceeding is accordingly dropped. The petitioner shall be at liberty to those petitioners who are aggrieved by the decision of so and so shall be at liberty to approach appropriate authority raising claim of higher scale of pay upon removal of anomaly. Pay anomaly. Yes. 57. As the order that 2/6/2021 has not been complied with. That is what is penalty authentication minutes. Yes. Yes, 10 lakh, sir. It appears that single union has a complaint under section 10 of the Contract Law Regulation and Abolition Act 1970, pending before the opposite part number 1. For the tendency of the conviction at the instance of the personal union at annexure 1, the person in present form is not at this stage. So your grievance has been considered? No, not yet. Not yet. Who had to consider? The opposite part number 1. Who has to consider party number 1? Principal Secretary of 2024. Now the opposite party 1 month. Have you seen it? Yes, and I have also filed a response to the complaint certificate. Whether the decision has been taken or not? No, that's not yet. Because the government has to constitute the advisory board, state advisory board. There is direction for constitution of advisory board. Direction for the decision is to be taken in compliance of the provisions of the contract labor regulation and abolition and and that mandates that the government has to take Mr. Counsel, if there is any direction, decide a case in accordance with law. And if the case is not decided in accordance with law, that will amount to contempt of court. Decision has not decision has not yet been taken. Yes, that decision has not been taken. Did you allow him, the opposite party number 1, to take his stand in the immediate proceeding? No, did you? Because did you allow opposite party number 1 to take any stand in the writ proceeding? I have sought advance copies and did you allow? But I am to allow you to go up to the court. Yes, I must up to you. Therefore, this is up to the court. This is up to the court to find out whether it is counted to the degree or not. Yes, that is what I want to say, point out numbers. The option to the direction, the state advisory board was constituted in 2021. And the term of the board is 3 years. Sir, Counsel, you must have argued for 1 minute for getting this order. And in the contempt petition, you are arguing for you argued 5 minutes. That is this. That is it's all because you did not get your dispute adjudicated upon. You just got an order for consideration. And without even, I understand. 600 because finally the request of I didn't make from the body. Mr. Counsel, the difficulty is that in contempt jurisdiction, the court has just to see whether there has been intention to violate or not. So, the jurisdiction of the court is very limited. I cannot go beyond. Yes, sir. But I want to point out the intention part members. Intention part I will complete. Another point, members. In the affirmative direction, this state article is to be consulted before taking a decision. Was constituted in 2021. The term was 3 years, but unfortunately only 2 meetings were held. During this year, the last one being in February 2023. In September 24, the law was expired and there has not been constituted. That means they have to constitute, they have to fix it there, they have to fix the agenda of this person. But otherwise, the other thing is the petitioner has alleged disobedience of an order dated 2/6/2021, passed in WPC number 610 of 2021. The each union, yes, each union, Orissa Power Employees Union, the Orissa Power Employees Union had filed a separate application seeking direction to the opposite party number 1 and 2 to inquire into seeking seeking following direction. First of all, the petition was disposed of in the following terms. Has restrictions के ऊपर तक. Stop. Next, a compliance affidavit has been filed on behalf of the opposite parties, wherein it has been stated that in accordance with the statutory provisions, the State Advisory Committee Labor Board would recommend to the state government for abolition/non-abolition of contract labor in an establishment. Establishment or area of operation, and the state government can issue notification under Section 10 of the Contract Labor So and So Act. Stop. When counsel appearing on the petitioner has submitted that though because of court's order, State Advisory Contract Labor Board was constituted, though the case was placed before the advisory and before the State Advisory Contract Labor Board, but presently the board is not available. Yes, but the term of the board has expired and no fresh board has been constituted. First off, in the court's opinion, no case of intentional disobedience of this court's order is made out. The order was passed without any counter affidavit and without giving any opportunity to file a counter affidavit based on the assertions which were made in the petition. Stop. This contempt application is clear and is dismissed. Lord 58. Contradiction. Lots of times the complaint should be reached. What is the order? I will not see the order. This order is I will see the order first. Order introduction. Taking into consideration the submission made by the one counsel of the parties without expressing any opinion on marriage. The conclusion is that the consular opinion since the default petition under annexure 5 is This is from the bottom, content number 9. Yes, page 9 from the bottom, second line. What's the bottom? Annexure. Annexure without. Annexure 1 to this. Annexure 1 started page 7. Page 5 is the direction. I have filed the certificate, copy of the order such. Would you order in there? There is that. No, there is nothing. Page 9. Page 9 is nothing. I answered the condition. What about it? Yes. Taking the consideration, the submission decision has been taken on your petition. No decision was taken. Two directions were allowed to be given. To take decisions and also after hearing both the parties. So these things are not done. And the municipal taking decision and municipal file, according to order, we proceeded another 2 meters. Maybe we are not concerned. When did you file the writ petition? I filed petition in 2020. Where lordship passed the order on 16/9/2020. Where one thing left, 2 contempts are filed. The other contempt is disposed of, country. And they are more than order 16/9/2020 first. It is a clear misleading false statement. Just a minute, who is misleading? Let me see. And whom? To the Tahsildar, that's good. And we have provided time. Where is the representation? Representation. Annexure 5, yes, page 22. Yes. This was directed to the disposal of below. Since no notice was issued, no decision was taken, no warning issuing notice. No warning issuing notice, Mr. Counsel. Yes. You filed a petition, that is first order. Yes. In the second order, you were not properly dressed, therefore the matter was adjourned. Yes. And on the third day, the writ petition was disposed of. So, sure. Not only saying that your lordship direction, I have read the letter. And now complaint submitted to your lordship commission. On the basis of complaint submitted, what I submitted that will is justified. And it is a misleading affidavit, false affidavit, very serious thing in your lordship commission. Para 8, complaint submitted, para 8, your lordship commission, page 4. 2 paras are there. Page 3, 1 and para 8, second rulers. Compliance affidavit is there. When did you file? 7/2024. Just a minute, just whatever. 27/2024. Which I think. Lots of fancy page 7. Okay, 50. Page 7, the order of the Tahsildar. The lordship has kindly page 4. There are two paragraphs, page 3 and second is page 4 paragraph 8. Second, page 4 paragraph 8 your lordship condition.
It's a nice page 7 nights.
But it is only submitted that since the order of the Honorable High Court has been complied, it is letter and spirit. And order dated 25/1, there is no need to pass order again, self-same cause of action. The petitioner is supposed to report it. And para 8, page 3. But while the matter said that the petitioner filed another contempt application, already known complaints of the order dated 15/1/2020, passed in this application 15/07/2020, and report after hearing and consent of the parties have been used to dispose of the contempt application, order dated so and so, with a direction to complete the order under the court, at least within the period of 15 days. Hence, we submit to complaint so and so. This is the order related accepted copy of the order and the government adopted the law on inspection. Subject to the law to condition paragraph 3 of it. Now, I will not see any order. I will not see any order. I am only submitting that how the false misleading evidence has been found. Therefore, in the beginning, I told you that who is telling falsehood, who is misleading whom we don't know. Yes, because the order was passed on the very first day. Yes, so the order was yet to see. The date of the order when the order was complied. Lastly, satisfies that the direction was complied. I have no question. Yes, yes. No respective submission is, it is the misleading and false evidence showing that it has been disposed of by manipulating documents. All right. Very serious awareness, very serious. This is not very serious. Yes. Here, even I am not asking that content 20, they have read. They refer to the content 20. Wherein they say that content order, the other area, two content petitions are filed on same day. 19 were pending, 20 were disclosed. 19 were also disclosed notice not. Now, we have last month, we are also disclosed notice, 19. Once directed to that is needed, we have to complete the order after repeated memos filed by me, we have to insert on 14/9/5/2004. 24. They are directed and issued notice to file for cause. Yes, in response to that, they filed this complaint. The complaints report in response to your last notice last month providing the length of leave. Notices issued to the consumer, they filed affidavit. While filing the affidavit, they have also taken note of the other people which was disposed of by this law with a direction. I have heard you, let me hear him. Before that, you know, the that order which was relied on the complaint schedule, paragraph 8, which I have created for your lordship. Separate copy. Otherwise, your lordship will put up the matter after one the petition. Which content petition? Content. Huh? The other content petition which they dealt with in the complaint schedule. This is unit 19. We are dealing with the lordship 19. Discuss matter on effects along with contempt petition 20. So there is one order petitions. No, we not one order, two orders. You know, our purchase, my father purchased by registered state three plots. All right, there were two orders. Two contempt order, two orders. two orders, two repetitions. Two repetitions. Yes. Because there were two repetitions. Yes, two repetitions, two contempt petitions. Yes. And both have been related. Second minute, now what is examine every hour. Caste one item number 9. Item number comply. Yeah. Problem. Item number 26. 10, 10, 10 is adjourned to 46. It's a 10 here. Here. 10, 10 I'm just adjourned to 46 and for 24 personal adjourned to 45. Can you observe? 46. Also personal. We item 46. And it is personal data. No. No. And Mr. Michael, 35 after instruction, where the father of the petitioner is received, he had filed an objection case, he was 356/2007 was. And in that village, there was consultation proceeding was going on, and because there was objection by the villagers, proceeding was de-notified. Thereafter, again, the villagers was approached the conduct for the initiation of the proceedings. So, by the notification, it has again. Now, so far as the present project objection gets, but there is a dispute, some Communist Party office there was proceeding occupying, and there is a lot of proceeding connection. And I talked to him that we also going on given notice because the operator never appeared, did not taken out. But then I don't to 7 years. And we have better that on that day we disposed of that proceeding. So after 25 in the meantime, 25. I don't know if it's time. No problem. 59.
I am for the petitioner, my lord. I want BC police.
After the inspection, this is directed to dispose of the grievance, my lord. No matter hearing going my lord on 25th by the end of the 25th minute, we dispose of the grievance. 25th, talk. 25th. As requested. I don't know, 60. 60 minutes, and some time will also be taken. Why? What's about the discovery? I have already informed in my lord. I'm not a simple. All right, 61, my lord. And order declared 14th September 2021 was not applied. Whereas filed the contempt petition and we have filed the complaints report on that. And I have filed the affidavit, the false one. And thereafter also directed to the opposite party to file a affidavit. The after file that affidavit, also two things are there. One is whether charge sheet has been filed or not, or the medical officer has been examined or not. Thereafter, let's be directed to the personal appearance of the opposite party. Which case record. And then we file the case record, whether the two things is available or not. So the order for additional time. Who are you? No? Who are you? And are you brother of the brother of? Brother of
side, who was assaulted by the opposite parties. Villagers.
And there is the order.
Right?
The order is of 14/9/2021. What happened?
There
What compliance? What is the compliance?
I have filed a litigation before the SP.
And what for?
For further investigation.
Where is the question of further investigation?
No, there is no investigation, basically FIR. They have filed a petition before the SP. And that has been disposed of by lordship. And we have filed a compliance petition, which was false one. Lordship directed to file an affidavit to the opposite party. Lordship, opposite party have filed a
Which affidavit is false?
compliance report that is 7/8/2022. There is a compliance report submitted.
Charge sheet or final report has been submitted or not?
Yes.
That's all.
No. And that was there. Thereafter, we filed an affidavit on 4th December 2023.
What?
Before the lordship. On that report, that was not disclosed whether they have filed charge sheet or final report or not. This is the reason.
What permission? The investigation is complete or not?
Yes.
That is the order. That was the order.
Never.
The petitioner is just reading of this court's order dated 14/9/2021 in CRLMP number 1347 of 2021, which was disposed of with a direction to the Superintendent of Police to consider the petitioner's grievance regarding slow progress. FIR was not registered.
Yes, what is it?
So the grievance was that FIR is not registered. That is what is mentioned in the order.
At that time, FIR was not registered. Thereafter, subsequently, it was registered.
So that was the direction. What else?
This which was disclosed with the direction to the SP to consider the grievance
Of the petitioner for registration of FIR. The FIR was registered pursuant to certain observations made by this court. The petitioner, however, alleged that no order has been passed on the petitioner's grievance petition. Stopping the aforesaid background, the petition was disposed of with a direction to the Superintendent of Police, Puri, to take a decision on the petitioner's grievance. Stop. It has emerged from the materials which are on record that the police have completed the investigation and submitted final form or charge sheet.
Charge sheet was final report. That was not final. So what happened? I'm sorry. What happened after the direction of the lordship, we have filed an affidavit. On that affidavit, we have not disclosed whether we have filed charge sheet or final report or not. Lordship thereafter directed to the IU and IAC, let me come and get that has been filed or not. That has not been completely provided.
Yes, what is the stage of investigation?
Lordship directed to take a decision on this allegation, my lord. So, his subsequent taking into consideration, my lord, Section 325 was added to the FIR, my lord.
Following is the affiliative portion of the order. Stop. I do not find any case of contempt of court without in the nature of order passed by this court, contempt proceeding is dropped.
In 62, 62 is complied with me. Item 63.
Order 16 was 16. Have not been compared. What was the order? Order was made. The land the commission to shift that down. And benefit and localizations. Yes. Thereafter, yes, I will comply with. You were highly suited speaking order was speaking order. What's it? After rejected by this court and there another two path. You forgot that there is no other content. And I will seek to 35 of the unconstitutional content system. Thereafter also one stated after stated in 85 2024 filement. I solution they are only for that the they are after step 3 years. And they are still the kind of jacket no not after 3 years. Last order, we are it is order. Order which has been disobeyed. What is my another one? Another one, the page 11 after the cards. Page 30. And there are some type. Considering the summation. Yes. Considering summation, you are talking about that and you are summation. But the common process. We note that at the government we expect intention to give our requested promotion to applicants in awareness transfer. So also this order similar to the teachers in the letter transfer ignore the original attention. The action had initiated in person to avoid letter by the director. Letter 7 to pending this session to present is similar to the teacher's transfer and most will take a different view. In that they are already that and the benefits. Once it's been directed to part of the order, applicant respond to public. That is the direction of some director. Important one SLP is very mellow. SLP having SLP dive number 16580 2024. 24 now. That was I guess some getting mark till the diploma removed. Last listed on timeline in the diploma attested and on director we normal section of a dispute without any so 6 expired. No challenge 6 more so 9 manner. We only 90 here. I think all right 25 it's from there.
I think 64.
My lord, in the first hour, I sought for an adjournment because today is my uncle's first death anniversary. So I pray, my lord, let it be after vacation, my lord, on 25th. I have some personal difficulty. I requested your lordship in the first hour. Obliged, my lord.
65 has not been complied because the actually kindly comes to page number. It is only a internal correspondence, but the benefit has not been assigned to the position. Where is the order? Lordship at operating person at page 11. Annexure 1.
Yes, what is the order?
Lordship page 12. Accordingly, the interim order is quashed, not being electable to the applicant. The respondent authorities are directed to take the applicant back in service further and extend all consequential service and financial benefits within a period of 2 months from the date of visit of this order.
Yes.
But so we are highly suited on 26 2024 mile, including the progress sleep mile and other benefit melody have written giving that it has not been extended to us. Correspondence election.
Yes, let me inquire from it.
What's the kind of the focus mile? Focus 26 2024 mile.
Take the applicant back in service. That has been done.
Well, that has been done.
And extend all consequential benefits.
Now, consequential benefit malady, we have already, the state government has allowed this malady and the rule is directed to submit some documents malady for complaints.
Submit your documents.
Documents have already been submitted by me also.
Don't submit.
I will again say, I will wish.
See, we have to, after all, the court has to examine their intention. So they have asked you to submit certain documents. So that's how their intention to clear your dues.
You have to page 17 of the showcase affidavit. Where engaged my recommendation, wherein I have submitted all the required information we have asked for. Page 17 of the showcase affidavit.
All right. Do it on the basis of, don't ask for any, the petitioner has alleged disobedience of an order passed by the Orissa Administrative Tribunal in OA number 1834 of 3, operative portion of which reads as under. Accordingly, the impugned order is passed on being relatable to the applicant, but of the respondent authorities are directed to take the applicant back in service forthwith and extend all consequential service and financial benefits within a period of 2 months from the date of receipt of a copy of this order and court. So, the petitioner does not dispute that in compliance of the said order, the petitioner has been taken back in service. Post-office, however, submits that the consequential service and financial benefits have not been extended. Stop. Next line, AGA has submitted that the petitioner has been asked to furnish certain documents for finalizing the consequential benefits in terms of this court's order. So, counsel for the petitioner, however, states that all the documents which the opposite parties are demanding have already been supplied. Stop. Next. Discuss matter on 25/9 and 25/10/2024. Stop. In the meanwhile, the opposite parties shall consider payment of, shall ensure compliance of the order to the extent it is possible, based the documents to the petitioner has furnished, as the petitioner is not inclined to supply further documents as demanded by the opposite parties. Yes.
66 complied.
Normal. I don't not compare and compare. You are seeing the page to have the glance to page 9 of the brief. The operative person is at page 9. My authority. I am pressing the operative person. In that view of the matter, since the petitioner is continuing in her post and has completed nearly 20 years of service, and even though her appointment is irregular, she should be regularized in service in view of the judgment of the Apex Court in Umar Delhi, ML Kosari, and Papi Hindurani, and judgment of this court in Binan Kumar Math and others. Accordingly, upper department of 2 to 4 are directed to regularize the service of the petitioner within a period of 3 months from the date of passing away. In person to this order, your lordship may please to have a glance to annex 2. Their order was upheld by the division bench is recovery. Was by the Honorable Supreme Court.
And after the order was upheld, they have, without regularizing my service, at page annexure 1A by 2 of their counter affidavit in the present contestation, they have issued a fresh applicant without any reference to my previous service of more than 20 years. This is the point.
What is meaning of regularization? Nothing. What is the meaning of regularization?
The previous service has to be taken into account the purpose of other notice and pensionary benefits.
Where is that law?
I will produce. Yes, ma'am. Okay, will not put any date, I will satisfy your right to on that. Because they are without appointing me from the
Therefore, I asked, what is the meaning of regularization?
regularization means this is the as per the law.
According to you, regularization means absorption.
Absorption.
Absorption. All right.
He is working since 1993.
Yes.
His business service from 93 to 2022 has not taken into consideration.
All right.
It's 20.
All right. In your case, I'll decide the regularization aspect also. What is the meaning of regularization? What is irregular? What is illegal? How far this MLKC and Umadevi they are applicable?
Right.
What are the subsequent decisions of this court?
Right.
So in present contempt application, I'll decide. All right.
Okay.
Yes. Appearing on behalf of the petitioner has submitted in the present contempt application that though the petitioner has been issued fresh appointment letter in the light of this court's order dated 21/1/2020, sorry, dated 27/8/2018, his service ought to have been regularized with effect from the first day of his engagement on daily basis. Daily basis.
10 years, the decision of the Supreme Court after completion of 10 years, that when 10 years completion, he has to not from the date.
From the date when the petitioner had completed 10 years of service, that is from 2000.
The first order is 98, 2008.
With effect from 2008.
Nine.
So he submits that the petitioner ought to have been absorbed in the government service in terms of the said order of this court. With effect from, they give me the date.
11/9/2008.
2008. So he submits that the, you have one this, your appointment may also go. This appointment may also go. Because regularization means your appointment, what was meant was irregular and that also be regularized. So you should not be removed till you continue.
I will take that risk a lot.
Huh?
Yes, madam.
You should. You should. Tell me. He submits. He submits that the petitioner ought to be treated. He submits that issuance of appointment letter cannot be treated to be compliance of this court's order, and the disobedience of this court's order is intentional, and therefore this court should proceed in the present contempt matter. Stop. Next, though I am not prima facie satisfied with the submission advanced on behalf of the petitioner that in the present center, in fact, present set of facts and circumstances of the case, the action of the opposite parties can be said to be intentional disobedience of this court's order from our sense-learned counsel wants to address this court on certain legal issues on the point of effect of regularization. First off, list this matter on 25 Yes.
67. No, this case may not be sufficient department. Hence, there is no contempt.
Yes.
68. 68, my lord, this case, my lord, the government has already directed the director and the benefit, my lord, kind of ransom term so that the other can complain.
25. 25.
No. 69. $69 million. Block 70.
Yes, they don't solve the so-called replying. We don't compare with them. They yes, compared with liberty.
71. The Benjamin never complained. And it has not been, you will also kindly see, I think there is no complaint has been given to me. You will also fix it to 25th, I will come out. I'll come to say that. 72. Hello. 73.
Yes.
Item 74. Lordship, item 74, Lordship. During non-compliance of the order dated Lordships, 3rd of January 2022, Lordship. More especially, Lordship, opposite party number 5. 73 complete. अब ये सोते affidavit. I'll give complete. Item 75. 75 is complete.
Compared.
76, there is my lord. That is what I realize that it has not been compared with our proceedings at parent 2 at the bottom. Wherein in book application number 3469 order. The order was that opposite party is the parallel court authority, chairman parallel court authority. He had issued a so-called notice to me that why you should not be treated as a person belonging to a different caste, whereas I belong to the civil tribe. Because this was on the basis of some extraneous influence that you have issued. So I challenged that before this honorable court. This honorable court was of the that only the state level scrutiny committee, which has been formed under a specific statute, which is authorized to examine whether I belong to a particular caste or not. The chairman of the parallel court authority has no authority to issue such a so-called notice. With such observation, this honorable court by this order directed asked me to submit my so-called reply to the chairman and also ask the chairman to take a final disclosure of my so-called reply and which should result normally in the document of the so-called. Thereafter, this honorable court directed that in case we find that so-called supply is not sufficient, then you can refer it to the state level scrutiny committee, which will examine the caste certificate of the petitioner. Unless and until the final decision is taken by the state level scrutiny committee, which will also be subject to the further appeal or revision provisions available to the petitioner. Unless finality is attained to the caste certificate, no courtship action shall be taken against the petitioner. It's got a clear direction below. After that, I submitted my so-called reply that was not disposed of, despite my repeated reminders to the appeal party that kindly dispose of that my so-called reply as per the direction of the honorable court and drop that so-called notice which was issued by you. Nothing was done. That is first part of the contempt, act of contempt. Second part is the SLC took up, of course, SLC took up an investigation on my caste certificate on the basis of some other person's allegation. That ended in a report that I do not belong to. All fallacious procedure was followed. That I have challenged before this only report. This only report has also
Mr. Counsel, is
no. What was the direction to the opposite party was not discussed of here.
these are not disposal, you should be happy. And see, the court had said that if you dispose it off, legal confusion that you don't belong to civil caste or civil tribe, whatever, then they will have to approach the committee,
Since statement is speaking from it. That has been stayed, my lord. That has been stayed by the Supreme Court.
What has been stayed?
The SLC report has been stayed. I have preferred challenge that also. This only report has been to state. At the moment, what is the second part? We will also been see the conduct of the intention. Some earlier case we heard, that's it.
See the order first. Direction to concluding. Yes.
I totally is correct to you. Considering the appropriate submissions made, it is guaranteed that the petitioners shall submit his reply to the sort of notice within a period of 4 weeks from the today, along with a copy of this order, and the same shall be considered by the Parallel Court Trust in accordance with law. Further, it is made clear that no coercive action shall be taken against the petitioner matter of adjudication of the by the Caste Committee constituted by the state government for adjudication of the caste issue. It is needless to mention here that once the Caste Committee decides the issue finally, after hearing the party,
There is nothing, Mr. Counsel.
thereafter I have filed an additional affidavit law. That is the second part of the contempt. In furtherance of this contemptuous affidavit, the moment the SLC disposed of my that investigation, without giving the opportunity. That was not regulation. He has issued dismissal order.
Yes.
He has issued dismissal order against me. He should have pointed out to the SLC that this is the order of the honorable court that unless there is a further remedies available, and I have already argued that
You can go and tell me where your matter is pending. The petitioner has alleged disobedience of
this matter is without any disposal of that.
this contempt application.
The fact of not having addition also.
All right, you will not allow me to write.
I'm sorry. Item 77.
Sorry.
77. No, item 77, my lord. Even though they have complied, but we have objection in their calculation. So liberty may be given to challenge. 78.
My lord, compliant, speaking out of class.
Can I pray for a short adjournment so that I can take?
I'll do it. Whenever.
Arrangement was to consider the presentation. They have considered with the speaking out. So you may kindly see annexure 1, that is the order. Consider the.
It may come reopening.
Yes.
79.
You have discussed with them. When counsel, when AGA appearing on behalf of the contenders has submitted that the order of this court violation of which has been alleged in the present contempt application has been complied with. A copy disposing of the petitioner's representation has been handed over to learned counsel for the petitioner. Most of learned counsel for the petitioner is however not satisfied prima facie about the compliance of the court's order. Stop. He seeks adjournment. On his request, the matter is adjourned to 25th.
Yes. 79.
Whether there is a order given on 12/5/2021, so we have to take any court.
79.
Yes, what happened? No, not to take any court action. So the matter is pending, repetition.
Revision petition. The document ID is page 41.
No, this WPC 1661 of 2021 is pending.
Disposal.
So you are alleging violation of an interim order.
There is no violation. We look at the order. The order will be 12/5/2021. It is open for the petitioner to draw the attention of the opposite party 4 and 5. The order part by this court in WPC number 74. In the event that court's action is sought to be taken against them during the pendency of the RP case.
You are alleging violation of that order. Well, yeah, I am imposing cost. The petitioner in the present contempt application has alleged disobedience of this court's order dated 12/5/2021, passed in WPC number 1661 of 2021, operative portion of which, operative portion paragraph 2 of which reads thus. Stop. In my considered opinion, the filing of the present contempt application is thoroughly misconceived and frivolous and dismissed with a cost of ₹1,000 to be paid by the petitioner of welfare. Yes. 1,000 cost. Well, we want to take a court action. But the duty can do that, outside the petition. For which the petitioner filed the contempt petition at that time. Yes. Well, the order was given that times the 5,000 people. Whereas the order, specific order that the Mr. Counsel, I have quoted the order which was passed. I have dismissed your contempt application with a cost. No. I'm sorry. And we also.
Item 80.
Yes.
80 compliant. Take the first one, sorry. 80, your lordship, may keep it to the next week.
25.
81. 81 compliant.
No. No, actually, it's not going to devotee.
82. 82, your lordship, may allow me till next week so that I can. But I'm sorry, my lord. 82 also compliant.
82, who is the parent?
82. Present compliant.
And see, answer one, page 8. 8. Yes. Last occasion also, that was 5/8/2024, this honorable assumed the possible which, what is the, this is CONTC 6543. 6543.
6543.
Yes. Yes. So what has been disobeyed? The last question. Who is written instruction, working documents, the person may be collected a copy of the ROR in the office of the person server cutter and making proper application. But video printing application. Yes. Yes, 10. 10 in the proper application.
Necessary correction has been carried out to the direction of the DRO. Regarding certified copy, I have not received any instruction. First have been given.
No content is around, but still. See whether if we have filed any an application. Next.
Next. 84. Another legal process. Unless you get test nurses, test for the regulation of the petitioner, or directly by the announcing bench. But then after this, I file one after using second amendment. So when after pending laws, the state went in opting laws. We have received that opting laws. And it's fine so that at 26/6/2022, starting there that since the so now we are seeing dismissed. So let's the company that was listening benchmarks. Compliance. You are not modification. Is there any modification? No.
Yes, sir. Yes, sir.
No, the result was not dismissed. What a title. Welcome. Some time.
All right. November.
85. Comply. 86. 86. That is matter of about to is matter. Under the you have got that is master. Number 3. Start doing well, which will be happened. To this amount, so you have no difficulty to affect the person. You will actually kindly see the order. Sir, one second.
86.
86. Item 86. Page 10. Internal page 2 of the order. Para 6.
Yeah.
Para 6. Having driving contentions and taking into consideration the nature of grievance, the writ application is disposed of with the direction to the OP number 3 to take a decision on the recommendation of the Commandant OSAP 6th Battalion Qatar to the AIG of Police Personnel, Orissa Qatar by letter dated so and so under Annexure 5 within a period of 2 months from the date of production of the certified copy of the order. Further, as it appears that a petitioner has secured 66%, she is eligible to be appointed under the new rule.
6% evaluation is on the basis of the rehabilitation assistance rule 2020, the new rule. She has secured the marks as required. As she has got the cutoff mark, the OP number 3 shall do well to give suitable appointment to the petitioner due to her qualification. But the sole intention of the order is to give her appointment in accordance with law as per the 2020 rules.
The appointment has been given or not?
It has not been given because as per 2020 rule, a list of the candidates, all eligible candidates has to be prepared. That is the requirement of the rule. Your lordship can give a glance.
You could have challenged this order.
But it is not that they will not give appointment. They have prepared a list. Name of the petitioner finds place at serial number 135. The number of vacancies is 75. Out of 75, 50% as per rules, 50% are to be filled up through rehabilitation appointment. So it comes to 33. So 33, the list is more than the vacancy. So her name is at 145, and in the order, the order which we have passed pursuant to the direction of the Honorable Court, that is in Sober's affidavit, my lord. There we have specifically indicated that once her position comes, she will be given appointment because he has been found eligible and her name finds place in the list. It is at 145.
What can we do?
That is
How can your case be considered superseding the cases of person senior?
My English submission is that according to their list, they are submitting the since 9 to the different height. They are like that the person in serial number 1 has not been appointed. 15 that is 25. So imagine you say that.
Making the submission in your favor or against your client's case. You are saying that the person who is at the top, even he has not been given appointment.
But it is not given appointment. So many
Appointment, then how can
my humble thing to online that. According to the law mind, it is like that the judgment, the law mind. This is actually 1 year, madam. Because we person, the law is
okay, right, you're right.
so that is past also,
All right.
that is also done well. Actually, so your order, we have to
Consider that your turn comes. Otherwise, the court may come in way. The court may say that no further, because after 5 years, 6 years, no such appointment can be done. The petitioner claims appointment, and the petitioner claimed appointment under a rehabilitation scheme. So by filing a writ petition, which came to be disposed of with a direction to voting party number 3 to take a decision on the recommendation of the commandant, Odisha State Armed Police, 6th Battalion Cuttack, to AIG of Police Personnel, Odisha. Stop. By observing so, the court also directed that the petitioner had secured 60%, 66% amount, which is above cut-off marks under the new rules. Amount, the petitioner should be given suitable appointment befitting her qualification. First off, it is the stand of the state of contenders, stand on behalf of the opposite parties that she has been found to be suitable under the new rules. The petitioner has been found to be suitable under the new rules because it is she or she is new rules because she has secured 66% to stop. It is, however, their stand that there are altogether 145 eligible persons and the vacancies are less. So stop. And then when the
More than 145, her serial number is 145.
no, we did more telephone. There are how many?
But total number of eligible, total number of lists is 212. Her serial number 512.
From 12 candidates. And the petitioner's name finds at serial number 145. Stop. The vacancy is much less than the persons eligible. First off, accordingly, they are being given appointment as and when their turn comes. First off,
Lordship may indicate rules 6(6), sub-rule 6(6) of the 2020.
in accordance with Rule 6, bracket 6 of 2020 rules, which reads thus.
While considering the pending application in an office, the concerned competent authority will consider all complete and eligible applications in the
Yes, considering the stand which has been taken on behalf of the opposite parties, in my opinion, no case of intentional disobedience of this court's order is made out. Stop. Made out. I record the undertaking given on behalf of the opposite parties that the moment the petitioner's turn comes, she shall be given appointment in accordance with the rules. Contempt proceeding is a topic. Yes. 87. Yes. Where is the order? Was the 9 para 6 only. 9 para 6 I am seeing, but what is the direction? Direction to consider the petitioner. Yes.
The Lordship will kindly see para 7 of this because affidavit. Where up to this, the petitioner had filed a original application before the tribunal challenging the departmental proceeding. And there, the direction was, in view of such submission made the land counsel for the parties, this court though not inclined to entertain the prayer as made in the writ petition, but direct opinion number 1 to conclude the proceeding. So initiated against the petitioner by memorandum dated so by end of December 2022, as it is submitted that the petitioner is going to retire on that date. However, it is observed that while concluding the proceeding, the state authority shall follow the provisions as contained under OCS CCA Rule 1962. This fact was not brought to the notice of the Honorable Single Judge. The Honorable Court disposed of the writ application with a direction that since the proceeding will take some time, so pending departmental proceeding, the promotion should be given effect. Now, my lord, in the meantime, the DP was concluded and punished, a major penalty was imposed, my lord. The major penalty was withholding of 2 increments with cumulative effect and censure. Now, since a major penalty has been imposed, during the currency of the major penalty, no promotion can be given effect by it. That is in view of the government circular that is stated in the law.
That is major concern. The question of promotion. Raise the question of promotion. It appears based on the appears from the stand from the government spending the proposed affidavit filed on behalf of the contenders that no case of intentional disobedience of this court's order is made out. The contempt proceeding is dropped. So the petitioner shall, however, be at liberty to question the correctness of the decision of the authorities denying the petitioner promotion. But that is not part of this denying the petitioner promotion on the ground of imposition of punishment in a departmental proceeding. The proceeding is dropped with this liberty. 88. Takes another five hours. Disposed of it. Yes, next. 89. I don't have a. So detective is not appeal, sir. I'll verify that. Yeah. Yes. 90. That's so. See that the order has been complied. That's why when we voted to annual decision, but because the said order was annexed to the next way to be interpreted. 91. That's from the other people that. Where the property has been filed. The property has been tagged to that hospital as yes, the bags have already been tagged. It appeal is pending. Yes. It appeal. 92. 92. Against violation of the interim order. Against violation of the interim order. Contempts are being brought. Yes, police for the petitioner. No. There's no representation. Dismissed. 92. 92. Around the 2020, Annexure 1 to Contempt Division. That was item 92. Yeah. Yes. That was violated. But that another contempt petition was filed earlier. That out of the annexure 6 2021.
Submitted director.
It's an issue. Which order has been violated?
Now, in 2013, we passed as a tribunal. From the regularized. From the regularized. That was how it was. So, abolition of the tribunal, I will repeat some different that order is unnecessary of the person. Directly to complete the tribunal shadow within 2 months. They did not complete another content. Director to complete the order is not complied 1 month. They have not complied. Now, in 2022, so filed a review petition for review of the order in the petition. In 2023, order is in 2023. That is filed to complete the order. How they have filed a review petition?
They can file a review application. Maybe where is the order? Your court, no.
Once about 2020.
Order.
Considering the solutions made, this court observes instead of issuing notice, it is applicable to one more opportunity to the approved party authority to come to direction of the tribunal by annexure 1. In that cases, by disposing of the petition, this court directs the approved authorities direction dated 27/3/2014.
So the review they have rightly filed. The order cannot be sustained.
But they have filed a review in 2023.
But this order without instead of issuing the notice, instead of issuing it, then nothing.
Review filed in 23 is not yet
Has alleged
not yet Mr.
obedience of an order of this court dated 10/11/2020. WPC number 2020. So from the order 10/11/2020 itself, it appears that the said order was ex parte as injunctions were not issued. So it has been informed that a review application has been filed by
RBW 73 of 23.
seeking recall of the change order. So
There are all other 3 matters in the list. Those also we have filed.
content will not entertain. Review in proceed.
Yes, ma'am. There will that from 23 that the two Mr. Madam. Let's just say after reading the petition, madam, said, I will
There is nothing. No order can be passed in the absence of
order was only to comply with President's order, madam. That order was to regularize from the date and not regularized.
and why are you not implementing that?
But the tribunal order was also passed without issuing notice. That was also order number 2. There also we filed a review petition in 2015.
2014, only filing
Orders. Say order. Stop. It is not worthy. When counsel appearing on behalf of the petitioner has submitted that this court had rightly not issued notice and passed the order because that related to implementation of an order passed by the Odisha Administrative Tribunal 27/3/2014 in November 736 of 2014. First off, apparently, the writ application for implementation of the order passed by the Odisha Administrative Tribunal was filed 6 years after passing of the said order. First off, Mr. Das and AGA has informed that even the said order passed by Odisha Administrative Tribunal dated 27/3/2020 was without issuance of any notice. Stop. In such view of the matter, I am not inclined to initiate contempt proceeding based on in the background of such admitted facts. The contempt petition, the contempt proceeding is dropped. Yes.
See, Commissioner also said that. We can have some, and we put some is that only appropriate.
Should. Yes.
Item 94. The reproduction of some kind of some direct
There will be a direction.
item 94.
Item 94, my lord, I am appearing through VC, my lord. I pray let the matter come on the next sitting because I am out of station, my lord.
Yes.
We have complied, we have highly complied.
No, my lord, the order has not been complied because
All right.
Item 95. So this is the retired assistant librarian who is scale of who was granted, who was not granted at the rate of 9,302, which is going to 4,200. And we will also directed, we will also see the order passed in the root of the minutes, that is their minutes. The root of the order is their minutes. When you do the matter, when you do
Where are you reading?
also the order of the root of the minutes, you must be aware of the single minutes, they are gone in the root of the.
Have you annexed that order?
Also, that is there in 18 so because we tendency of the case now also we had a file the root of the.
You are reading something, can I also read that?
After disposal of the rent of it, we have to listen to this thing. No matters. So that's not the matters. That is already dismissed. And 6/9/2024 matters. 6/9. The order of the 6/9/2024 matters. Upon hearing the council, the court made the following order. In the condemn, we are not inclined to interfere with the income judgment.
Let's find out.
For each time, because the SLP has been dismissed on 6/9. Also grant us for each time.
No, totally.
Item 96.
The order of the summary court, they did one thing first. As well as by the action that not by building the house and that is the reduced. But if you continue part time, the action that is admitted that rules the order some is not being this. That is the explanation of the word. But I have stopped. It is admitted that I have submitted the defense which has been taken, that is the defense which he has taken. That can you prove on the basis of any evidence that was served on you? Yes, I have served. Now, the investment is going to yes. And when wall is demolished, December 28, 2022. Yeah. And before that, stop. Huh? December 22. And we will be past. July 21. First July 21. And when did you inform? I informed 3 days before. 4th April. No, that's admitted. Continually admitted. Say that it was sent to me. It was given to the office. It was received by him or not. But I have sent it to the kindly see the papers affidavit. That's it. The entire report was called for. The encroachment cases has been initiated. The encroachment proceeding, the specific finding is that the petitioners are not in possession of the land, and the persons who are in possession of the land, they have been removed and their encroachment has been removed. So far as receiving the order of status for this honorable court, that basically an intra-party dispute between, because private parties have been included as parties in both sides, my lord. Now that petition, status quo order was passed. Status quo order was communicated, and that was received by the office and subsequently received by the Tahsildar, and by that time the possession has been removed, my lord. But so far as the findings of the report, it was also been specifically stated in the affidavit that the petitioners are not in possession of that land. Only the encroachers, those who are in possession of the land, they have been removed. And it is specific in para 6 years also. I have some formula. I'm relying on this postal this thing. But dark. Yes. Huh? They have also saved them. And but they wait. This is yeah. Sure. Is this your communication? When did you send it? Question of admission. It says counter number 4, 22/1/2021, 52. Yes. Can you see? Yes, ma'am. But the date is 22/1/2021. And you are saying approve something. Mr. Counsel, when did you dispatch the order? I dispatched the system register. In support of, so what is the date? I did mention on 4/4/22. 4/22. What is your outer number 4, the 22/1/21. This is you are making a false statement. It's with the respect and postal mirror, it is respect to postal mirror. Respect to postal mirror. Respect to postal mirror. This is 22/1/2021. Yes, 4/22. What's that? Counting number. It is very clear. Success. No question of verification. Something is going to be truth. The petitioner has alleged disobedience of an order of this court. Yes. 1991. Amendment, when I was asked service of notice, actually amendment is not this, not the Seven. Entering order of this court dated 1/7/2021. Passed in Saddam, passed in WPC number 9281. Postal track, so that no, it's not gonna pay. Oh, sorry. What's it being launched? Subsequent paper. The order, the respondents, the opposite parties in its application were directed to maintain a status quo as on the said date. The counsel appearing on behalf of the petitioner has stated that by the same said interim order dated 1/7/2021, Tahsildar demolished the construction in question. Mr. Caste and AGA appearing on behalf of the contenders has submitted that firstly that the Tahsildar did not have any knowledge about the said interim order before the construction was demolished. So he has further submitted that the constructions were demolished after giving the persons who were in illegal occupation over public land after following a procedure. So the petitioner was not of the land in question, and therefore he cannot maintain a grievance that any of his construction was demolished. So next, learned counsel appearing on behalf of the petitioner has attempted to convince this court that the said order dated 1/7/2021 of the court was communicated through post on 4/4/2022. 4/4/2022. So despite that, the construction was demolished. So next, be that as it may, I am not inclined to proceed in the present contempt matter. Also, Mr. Das has submitted that is primarily a dispute between inter-party dispute between the petitioner and other persons who were found in unauthorized occupation of public land by making permanent constructions which were removed after following the proceeding. So next, noticing the above facts and circumstances, I am not inclined to proceed in the matter. The present contempt proceeding is dropped. Yes.
Item 97. My lord,
Yes.
my lord, I mean, for the petitioner in the contempt case number 1138 by 2023, filed on 16 February 23, arising out of writ petition number 23913 by 2021, where the High Court had been kind enough to pass orders for removing encroachment of a village pond and issue directions to the Tahsildar to complete encroachment.
Where is the order? Where is the order?
Tahsildar, after receiving such orders of the High Court, didn't initiate any action within the first 6 months period granted to him. And
Where is? Where is the order? Yes. That is one. Page 3. Page?
yes, my lord, even after this, sir, my lord, I was forced to file the second contempt against the Tahsildar, bringing to the notice of the Honorable High Court the non-compliance of the High Court orders.
Please wait. No. Please wait. You're right, today, we take contempt to say the order was passed on the very first day.
My lord,
The order was passed without issuance or notice.
the notice was issued, sir. The second contempt was filed. The Tahsildar went on filing wrong reports to the High Court, misleading the High Court as if the work was done. Actually, the removal encroachment was not removed. My prayer to your lordship is only to cause an inquiry so that the truth is found out. Tahsildar, sir, I'm not able to hear.
The first day it was disposed of on 4/1/2022.
Audio is not clear, my lord. My lord, I am standing before you with a prayer so that you will cause an inquiry into the matter to find out the truth. The Tahsildar has been misleading the High Court repeatedly by filing 3 times wrong reports.
That will not be court's power. The petitioner in the contempt application has alleged disobedience of an order of this court dated 4/1/2022, which reads as under court covenant. So, it is apparent from the order that it was that without issuance of notice, the said order was passed on the very first day when it was taken up. So, next learned counsel appearing on behalf of the petitioner has attempted to convince this court that the petitioner had filed had earlier filed a contempt application alleging disobedience of the said order. He submits that the opposite parties have misled this court in this said regard and earlier also. So, however, from considering the fact that the order was passed without issuance of notice, the private persons were there. Private persons. They have issuance of notice to the private persons who were also impleaded as parties. No case of deliberate notice court's order is made out. This contempt application is dismissed. Yes. Item 98. And the order dated 2015 not complied with this.
Yes, SLP was filed, then SLP were dismissed for default. Then restoration applications have been filed. and those are pending. And take further instruction, you will also be keep it to
25. Nobody. It will come after November. Okay.
8/11. Item 99 for the compliance certificate has not been implemented.
What is the order? Let me see.
Order it was 8. Para 5. Considering the submission made and the limited nature of grievance, involving the present restriction, this could direct the special certificate officer from sub-collector Orissa to complain proceeding the period of 4 weeks from the date of production of the certified copy of this officer. Your Honor,
Instructions concluded.
8/11. And this is arising out of the 6,010 disposed of. Thereafter, certificate cases will file. In certificate case, they have not disposed of this one till and he's moving here to the remedy. Well, that's it.
My lord,
You need to seek instructions.
my lord, this is second contempt claim of RACP grade pay 6,600, my lord. And tribunal passed order as per NHR 1, my lord, on 21/10/2016. And in the second contempt, your lordship given there were several chances to comply the order, my lord. In spite of that, they have not complied. And as per NHR 7, my lord, they have complied in identical cases. And it is also Supreme Court based in the identical case, and they have complied that order, my lord, as per NHR 7. But in my case, they have not complied that petitioner. It is injustice towards the petitioner, my lord. This after 7 years, more than 7 years, they have filed the appeal, my lord.
Since the order passed by the tribunal, we have filed a writ petition challenging the order passed by the tribunal, which is pending, madam, where notices have been issued. And the matter has was last adjourned on 8/7/2024.
Yes, madam, that order is under challenge.
My lord, after more than 7 years, they have filed the appeal, my lord. But complied in the identical case, there were several identical cases, my lord. As per NHS 7 and NHS 6, I have annexed, my lord, in this case. But in my case, they have not complied, and simply to harass the petitioner, they have filed the appeal, my lord. Completely injustice towards the petitioner, my lord.
Why did petition was filed after so many years?
Yes, my lord.
No, I am putting this question to, yes, why? What is the,
The petition number is 13301 of 2024.
what was the order?
As per NHR 1, my lord. That is page number 12, my lord, in the last line, para 5.
Identical cases, and the tribunal had passed similar orders. Petitions were filed before this honorable court, but taken up before the division bench and dismissal. After dismissal, my lord, SLP was filed in 3 cases that we have stated in this focus affidavit. Page 3, para 6, specifically, the SLP are pending, where the honorable court has issued notice. So that is why they have, in the present case, they have also filed a writ petition.
As per Annexure 7, my lord, SLP is dismissed, and in that case, compliant. Similar identical case, and the employee of the same college, they have implemented the order. That is Annexure 7, my lord. The employee of the Khalikot College, Barampur, and petitioner is also employee of the Khalikot College, my lord. And they are same footing. Both are demonstrators. There is no difference at all, my lord.
He is saying that in the cases pending before the Supreme Court, notices have been issued, similar matters. Madam. Notices have been issued by Supreme Court in some of the cases.
How the Supreme Court dismissed the Annexure 7, my lord, in that case, and they have implemented that case.
So in some of the cases, they have.
But that case is not pending before the
In some of the cases, they have filed appeal before the Supreme Court. Supreme Court has issued notice. The issue is yet to be decided.
In my case, they have not gone to Supreme Court, my lord. So simply filed upon the Supreme Court.
Because they have filed writ petition here.
In that case, Supreme Court case has not clearly mentioned or it is not to be imposed to other persons. It is a clear-cut order for all the petitioners, and it is applicable to all the petitioners.
Also, this case on 8/11/2024. So it will be open for and counsel for the state to take steps for urgent hearing of WPC number 13301 of 2020, which has been filed against this court's order dated by the tribunal dated OAT dated 21/10/2016 in page number 10 bracketed B of 2004. Yes.
There also my friend has entered appearance in the right position. They have also entered appearance.
Lost.
Yes, sir, this is item number 1. Item number 1 to 7, I think that was 8. Item number 8. This item number 8, order has been complied with.
Yes.
Item 9. 9 also not speaking order has been passed, order has been complied with. Speaking order has been passed on 22nd December 2022.
Yes.
I'm giving the opinion. Item number 10. Item 10. That's then your special according to the affidavit is 5%.
So this for private.
Yes, I find complex affidavit also. Item 11. 11 was speaking order has been passed on 17/9/2022.
Yes.
Item 12. It relates to Orissa Rural Housing Development Corporation. But somehow when given copy to me, was they stated that it's a housing loan bill. Finally, they stated that present one time settlement scheme for settlement of loan
There is no scope on the part of your to consider the intention.
Krishna, Mr. Samantra and AGA has submitted that though he does not have any instructions to appear for the Odisha Rural Housing and Development Corporation, he has been handed over a copy of the letter dated 9/7/2024. Whereby from which it appears that in the light of this court's order, the petitioner's case has been considered. Post of the said communication is taken on record. The proceeding stands strong.
Item 13. Add or not?
Has not been completed.
Yes.
Here in this case, you are applying to page 7 of the order. We 7 page paragraph page 7 paragraph 4. Restriction. Therefore, we have the detailed reasons stated in the judgment and order dated 11/12/2021. Passed in WPC number 5301 of 2022. The restriction disclosed of law. It is that we have 5301 of 2022. Recopy is order dated of the order by the recopy of 687 of 2022. I think that order has been much very. The original order is only relying this order with that order is very low. Something to verify this and also. So from that you don't have any idea.
Well, I have idea. The recapitulation has been allowed.
Then
The petitioner has alleged disobedience of the sports order dated 22/12/2021, which into be disposed of by which has been disposed of in terms of the order passed order dated 11/12/2021 passed in a batch of passed in WPC number 33301 of 2020 and batch of cases. So it has stated at the bar that the said order dated 11/12/2021 has been set aside in an intra-court appeal.
yes, recopy number 687 of 2020. 687.
So, in such view of the matter, in my opinion, no case of deliberate disobedience of this court's order is read out. Contempt can adopt accordingly. Yes.
Item number 15.
Withdraw.
No, 14, municipal corporation rules are written on the assembly. Item 16. Yes, item 16 is well assumed.
Yes.
1811. 16.
Next week. Next.
1811. Item 17. 70% half time and item 19. 19 was 500. That's as expected. Because of the time you depend that.
Yes, ma'am, that's it. Good. Complied with.
Yes.
Yes. Complied.
Item number 20. Yes, complaint is speaking order in yes, and giving a copy to the chairman. Item number 21. Was the recopy of 944 of 2023 highway is pending.
Yes,
944 of 2023.
I appeal.
Item 22. 22 was after response, representation and take instruction.
Yes,
Item 23. 23 compliant.
compliant.
24.
This order is having us has not been complied with.
Let's see, so Municipal Municipal Corporation, some of the PTV and any regulation speaking order has been passed.
Liberty, compliant with liberty.
Item 25.
Non-compliance about it is 6/2022 year also. The order is 9 year also.
Yes,
Speaking order has been passed and we will do the possibility. Nobody will also do it, will not comply with it. Item 26.
this is done for the Secretary of Municipal Development Authority. Direction to pass a reasonable speaking order of implementation time. That we have already complied with on dating 1 that has not been completed. But the women speaking order is status based granted in construction. That has been now located. Shortage by I have requested my license of shortage supplies some of them I already supplied the shortage license matters. As 2023. Ordering question. That ordering question is to dispose of the representation proven by the order. Ordering is now at this start constitution. Mixture and mixture one. Page 11. What is the order? Start a repetition, page 12. The secretary to take decision as appropriate. And that also putting action undertaken by the right and inspection undertaken affecting the access of the petition of question as no avail. That is order. But there are taken of this petition matters. The secretary is not participating in all development activities, but so far is concerned, we are being bound by once that he does. But in the direction to the secretary asked all the officers, record all the data to see, and thereafter asked in order that is the no violation, the status quo is implemented, and the allegations made at first fail under the higher petition colors they are not made. That is what we do. And by reading order, the case has been disposed of, and the arguments very also we are present to communicate with the citizen to never arrest. Now he says that we have I have never gone to that. That is not focus. That statement is written on someone that focus which I will answer. For 1918 that now just I'll tell you. 28 है 26. Petition. When did you file the petition? There was an issue. Whether before passing of the order, notice was issued to the other side. And how can we raise dispute now? No, notice the direction was issued. Direction was issued, but notice was not. Direction was issued. No, that will also make an say. The order was issued. Order was communicated on as well. Whether order to pass after notice. No. What is the secretary direction of issue secondary disposal. Sorry, that has disposed of. Sorry, you are raising such disputes which were not there before the court. There the secretary order of the person. They have blocking. They have allowed the land. They have blocking the 1% of the urban person. They will say the submissions which you are making here, whether you had made there in the proceeding.
So you have made the submissions. Yes, madam, you had made. Did you give the other side an opportunity to answer your submissions? So unilateral. So all we see, and now in the contempt proceeding, I cannot consider the submission you are making. But I am just coming. The order was passed, that's communicated. I understand that after the order was passed, it's communicated. But before the order, that is very important. The purpose always service to state. Then the order was passed, we are paying for the state. No, that contempt application has been filed for disobedience of an order of this court dated 13/12/2022, passed in WPC number 32560 of 2022. So the allegation is against the officials of Bhubaneswar Development Authority for violating the court's order. Stop. It is an undisputed fact. It is an undisputed fact that before the said order dated 13/12/2020 was passed, Bhubaneswar Development Authority was not noticed. Stop. This order or the order of this court was brought to the notice, subsequently brought to the notice of the officials of Bhubaneswar Development Authority. Stop. It is also not in dispute that in the light of this court's order, a decision has been taken by the Bhubaneswar Development Authority. Learned Council, hearing on behalf of the petitioner, has submitted that the court had directed for maintaining a status quo in the construction undertaken if it was affecting the access of the petitioner towards national highway side. Stop. These are disputed questions of facts which cannot be gone into in a contempt proceeding, particularly when those aspects, when this aspect was not addressed in the writ by issuing notice to the concerned opposite party. Stop. The contempt proceeding, one, the contempt petition has no merit, the application has no merit and is accordingly dismissed. And the address that there is only restriction was there, I will only that is the only answer you could have stopped disposal of the writ petition. You could have made a request that they should be given an opportunity to answer. Otherwise, any order passed in their absence, how can that be implemented against them? But once the order was all up to the notice, I will have liberty to educate his grievance before appropriate forum in accordance with law. 27. Item number 27. Which means corporation like who on appears dismissed. Item 28. Will keep us order will compare 4 lakh has been paid. Good. Item 29. 29 of the speaking order and item 30. 30 also complied with your speaking order has been passed. 31. 31 also your 6 complied with and speaking order has been passed over. Item 32. And therefore, we should have a item 32 to 40 filed in next week. Why, sir? Sir, a similar request. Let me see the order. What is that? That I will comply with this Odisha State House, but I have instruction.
It hasn't complied with the council. Why shouldn't I join? Comply with
But I will reject item 32.
liberty? You will have the liberty.
Item 32 to 40. Yes. Item 41, the government will comply with.
Yes.
42. Some time is required.
Yes. Next week. November.
Item 42.
Yes.
Items. First time it has come first time plus.
All right. 25th.
44. 44 comply with.
Okay.
35 comply with. You cannot no.
Liberty.
Item 46. 36 read the page 5 1623 of 2024.
Yes.
Item number 49. 49 comply with.
Okay.
49 non. Item 15, second complaint, not complied, the second content, not complied, the admission 7,50,000, they only there 6 lakhs. That amount not there, we get, we spend 2,000. If we is directed to remove the comment, you can get it there. That's 150 lakhs, not 100. That's 24 lakhs.
Annexure.
Well, 24 annexure series was.
Now, where is the order of this court?
Order number is 7 and first contempt order number 22.
Sir, why are you showing first contempt? One contempt is sufficient. So just show me the order passed in the rate process.
7.
It's 17.
17.
Annexure?
Annexure 1 was.
No, annexure 1, no, annexure 3.
No, so annexure 1.
Annexure 1, no.
Yes.
All right. What is the order? Take a decision.
There are take 24. There are take 24. Annexure 4 series take 24.
What is this going to work?
24.
Which annexure? Same annexure.
Annexure 4 series.
Yes.
The contempt directed to consider the duty officer to release. Directed to terminate the breach. That's annexure 5. They only say 6 lakhs out of 7,50,000.
You are directed to make payment.
Yes.
As per annexure. So that is not here. The petitioner has alleged disobedience of this court's order dated 39/2022, passed in WPC number 25630 of 2022, whereby, without expressing any opinion, this court had directed the opposing parties to dispose of, to look into the petitioners and take a decision. So the petitioner grievance has been looked into and a decision has been taken. The petitioner submits that as per the said decision, the petitioner is entitled to payment of 7.5 lakhs. Only 6 lakhs has been paid. First off, there was no direction by this court for payment consequent upon the decision which was required to be taken on the petitioner's grievance. The petitioner's grievance was cleared and substantial amount has been paid. Stop. In such view of the matter, no intentional disobedience of this court's order is made out. From petitioner shall, however, be at liberty to pursue his grievance relating to payment of less amount than his claim. Yes.
Item number 52. 52 filed the so-called second contempt, they will file the reply matter. The paragraph they mentioned that similar court cases was pending, 5 cases was pending before the Honorable Apex Court. So the complaints be liable to this of cases. In paragraph 12, and the cases numbers. Yesterday, subject to the lordship permission, I have collected all these 5 cases has been dismissed by the Honorable Apex Court. So, subject within the date revolution, and that order, I am supplying a copy. And all these 5 cases has been dismissed on different dates by different benches. So, lordship, after
811.
811 is for public. Item 52. It is compliant. No. It is partly compliant. Can we have a glance to the complaint summary? Case 2.
No, I'll see first the order.
Order is also. Order case 3 of the contempt application, 18/4/2021. Considering the allegation involved in this matter as a decision of such a ultimately on the appeal that this petition can dispute with the direction possible estimate opposite party number 2 to link into the grievance of the petitioners. But annex circular may involving the parties. With the director of the passenger shall initiate an appropriate proceeding following the provisions contained in the appeal. Admit unauthorized encroachment and decide the same within a period of 2 months. And they have not complied. This content application, and this only directed the complaint over it. But that can have a glance to
what has been complied with?
The first paragraph 8 of complaints are case 3. When the provision of the record is within that, the enforcement case is visit to destroyer, but enforcement case number being to case occurs. That is 224 and I think that the editor from Platinum 5.7 or more the Rasa Grahavan on the enforcement area 5.9 and area full disclosure question there.
So any proceeding has been initiated for removal of encroachment.
Initially, and they have partly diminished the enforcement.
The petitioner has alleged disobedience of an order dated 18/2/2021 of treaty portion of which reads thus. Again, considering when counsel appearing on behalf of the petitioner has submitted that in the light of this court's order, proceedings were initiated and the encroachments have been partly demolished. That all the encroachments have not been demolished. First off, they are removed. There is no, it is manifest from this court's order that there was no direction for a removal of encroachment. The direction was only to decide within 2 months the encroachment case, giving the parties an opportunity of hearing. Stop. Next, it is unfortunate that had you included the private parties?
Yes, yes.
Huh?
Yes.
It is also apparent that the private parties, who according to the petitioner had encroached upon the public land, were not noticed before passing of the order. Stop. In such view of the matter, the petitioner's submission that all the encroachments have not been removed cannot be considered in the present contempt matter. Contempt proceeding, the contempt proceeding is dropped. Yes.
Item 54.
No liberty. Sorry.
54. 54.
Comparability. 40.
55. 55 complied. 56. In view of the order dated 28/11/2023, no further order is required to be passed, madam. So actually see that order. 28/11/2023.
So what should I do then?
We should wait till the WA dispose of the all rights.
Let me see. 28/11/2023. So that appeal is pending.
Yes, sir.
No, but why? The appeal is pending, then why contempt proceeding should remain pending? No.
Ultimately, state. I don't know.
No hypothesis. The question is, what was the intention of the opposite parties? Either they accept the order or they challenge the order. So if they accept the order, they have to implement. Otherwise, if they challenge, they have.
They challenge it on the states. So the states are a limited here.
WM, relatively pending. Wherein an interim order has been passed, to stop survey of the matter of intentional disobedience of this court. Without dispose of civil property. Yes.
Item 57. 57 complied.
And
Item 58. 58. 58 has to be some time.
811.
Item 59. 59 complied. 60 complied. 61. Yes, 61. 61. Yes, ma'am. That I will contact.
Compare with 51.
62. 62 वाला I am authority का appeal करने वाला appeal करने सरपंच हॉस्पिटल जान पंचायत नगर I am authority का appeal करने वाला सरपंच हॉस्पिटल जान पंचायत टाइम रिपेयर टू फाइल स्ट्रेटजी प्लान वाला हम प्लान शब्द ऑर्डर करने वाला appeal करे ऑर्डर करने कंप्लीट वाला
60. Let me see.
He is appealing to the surplus, but the instruction is that I will comply with. This content for opening the floor matter, where I think he was there. It's to be ordered, let's
See the order first.
wait, madam. The petitioner values 8% seeking for a direction to the opposite party 3 and 4 to pay salary. He further says for a direction to the opposite party 3 to pay differential salary effective from 24/7/2015 to 39/2015 and that has been complied. And opposite salary effective from 8/10/2015.
Choose that. So where are the
Order number 2. In view of the aforesaid limited duties of the petitioner, for reading this. Second paragraph, I'll see the operative portion. Read the operative portion. Will whoever the applicant should have a limited grievance of the petitioner without expressing the opinion on the merit of the case. This court disposes of the petition directly opposite one to decision on the representations of substance decision. Yes. No, madam, they are not noticed. Sometimes notice the proceeding. The petitioner has alleged disobedience of the court's order dated 24/7/2019. Passed in WPC number 12359 of 2019. Whereby the petitioner's petition was disposed of with the direction to the opposite party number 4 to the writ application to take a decision on a representation filed by the petitioner. Mr. Putial and AGA has informed this court that law development officer, yes, ma'am, that law development officer has complied. This is the has informed. The video has informed him that Sarpanch of the concerned Gram Panchayat has complied with the court's order. They give the order. Ask for the give. Yes, sir. I will. A copy of the said communication has been handed over to the counsel for the petitioner. In any case, in the court's opinion, since opposite party number 4 was not noticed before passing of the order, for my opinion, no case of intentional violation of this court's order against him can be said to be made out. The present contempt proceeding stands stopped accordingly. 63 complied. Complied. Item 64 complied. Yes. 65 complied. Complied. 66 ransom time. 11. 67 complied. 68 ransom time. 11. 69 compliant. Item 70 ransom time. 11. Item 71 compliant. 72 compliant. Item 73 ransom time. 11. Yes. 74 ransom time. 11. 75 ransom time. 75. 11. Okay. Item 76 will also ransom time. 77 present appeal so and so. We are paying for private appeal. We are paying for private appeal. Right, private appeal 1 to 4. There appeal package 3,000. You are appealing for private appeal. Content. Violated the order dated 19/1/2020. You are for the petitioner. It's another. What is your where is the legislative issue to opposite party number 1 to 4? Who are there? Private opposite parties? Who are there? Now, let me see the order. Order number 9/27. Just a minute. Where is the order? Page number 9. Extra one. Answer one. Yes. This case along with WPC number 1413 of 2020. Yes. So the repetition is pending. Both cases pending. Both the cases will be heard together. 78. Compare. Compare. 79. Complied or not? It's not a question of compliance, my lords. Allegation that we have violated the you also violated. So that means, my lords. Yes. The order was immediately given to your client also. Let me see. So far, let me see the order first. 79. Discipline. By the way, page start from page is 7. The operating person is page 8. Oh, where is the order? Order is page 8. Page start from page 7 and the operating person start from the last person of the page 8. Yes, very difficult, sir. Yes. Accordingly, it is order. For 7. Very difficult. Admission stage. First day, admission stage. All the cases we are deciding in this High Court at the stage of admission. So you will be admitting cases. So you will be admit cases. Yes. You will make specific prayer in your petition. Let's say, admit. Yes. Well, there is no question of admission. All the cases are calling upon the opposite parties to show up, but yes. So, but there is no admission. Yes. All the cases are this is one aspect. And it's a compelling circumstance because which we are doing it. But the first day, how can you claim? The petitioner raises disobedience of this court's order dated. Petitioner will not pay. I'm the operating party. Who is the petitioner? I'm the operating party. Petitioner is not there. Not there. No. Yeah. Yes. Totally. What complied? 81 complied. Item 82. 82 madam complied. 83. Ransom time. He complied with me. Complied. 83. Complied. 84. 84 is complied with me. 85. 45 now complied with it. 86. So complied. 87. Paragraph 722. Concluding part at page 7. It's same complied with it. Complied. Or 88.
It is not complied, not complied with my lord. You have seen, you have purpose of change standing, I will be that delay. And will achieve this under. I believe
You belong to me, petitioner or counsel? Then you, instance also belong to the same village. Please forget that you belong to the same village when you are arguing the case.
So
You will have to forget that.
one thing,
Yes.
this honorable please to direct, let me see the order first. That is 65 to 5. Then you have your resolution. You have to read, then second contempt, that is number 5533. So you so in case of that is 9.
Where is that?
That will have to that's seven half content. Six photograph.
Sir, why are you referring to first contempt? The order was passed in the writ petition. So I shall confine to that.
There was a 9/7 also, that is.
Where is that order?
9/7/2021.
Where is that order?
Page 7 also.
Page 7 is some other order, Mr. Counsel.
Page 7, 5 also. 4.
Difficult, Mr. Counsel, that is something else. That is not passed in writ petition. Yes, what is your standing?
No, we have complied with notice matter call and call. This is case of eviction matter. Without hearing the encroachment. I will file an affidavit now. Complaint has been taken place. They are not complied with the order. I will file an affidavit.
No, fine. The petitioner has alleged disobedience of an order of his court passed in WPC number so and so, a copy of which has not been brought on record. This contempt application is dismissed on that sole ground. Yes.
Item 89. No liberty. 89.
Compliant.
Item 90. 91 complied with. 91.
91, my lord. I mean virtual page 10, my lord. My lord, obliged.
92.
Ransom time. Right. Right, Lord. Yes.
93. 93 complied with.
Liberty.
97. 97 complied with.
Compliant.
Item 95. Complied with. Item 96. 96 complied with. 97. 97 complied. 98. 98 also complied with.
Yes.
Item 99. 99 also complied with.
Compliant. Yes.
Item 100. 100 also complied with. There are 5 compliant.
Compliant. Yes.
101. 101 also complied with.
Yes.
102. 102 complied with. Compliance of the right.
Yes.
102. 102 also complied with. Order 7. Item 104.
Your Lordship, in item 103, I appear on behalf of the petitioner.
It has been complied with, Mr. Counsel.
Yes, Your Lordship. Yes, Your Lordship.
Yeah.
104. 104 my lord, compliance affidavit filed, order compliance.
Yes.
105. 105 also complied. Compliance affidavit filed. 106. 106 my lord, compliance affidavit, my lord, picking on a 106.
Complied with
107. 107 also complied. Compliance affidavit.
yes.
108. 108 also complied. 109. 109 also complied.
Yes.
110. 10 also complied. 111. 111 complied, compliance affidavit filed.
Yes.
Compliance affidavit not under the
Complied with me, complied with 7. Complied with
item 112. 112 complied with. 113. 113, which is it will be next one.
811.
114.
Complied.
115. 115 also. 116 complied. 117.
117, I am appearing for the petitioner, your lordship. They have already complied, your lordship.
118. 18 my lord complied. 119. 19 also complied.
Complied.
120.
And complaints of product 9/1/2023 value. The relevant question is ordered to page number 11. Complied with or not? Not complied with.
Yes.
But here the similar matter, but pending before the honorable apex court.
The Thailand court showing the similar matter and will apex court to granted stay order. But in this case, we are essentially
Lieutenant destroy case that is pending before the honorable apex court, similar matters are pending, so that is the so-called side. Present case, I'll take instruction what.
25.
121.
compliant.